ako se slažete, bi smo počeli uz jedno baš malo kašnjenje. Želim u ime Mansa, organizatora konferencije, da vas pozdravim i da poželim uspješan rad na drugom danu 14. Nacionalne antikorupcijske konferencije. Samo bih se kratko osvrnuo na ono što smo jučer čuli na konferenciji prvog dana, gdje smo razgovarali nakon uvodnog panela o finansiranju političkih partija, o političkoj korupciji, o tome koliko je zapravo izborna reforma trenutno zarobljena onime što imamo kao političku sliku u Crnoj Gori. Nakon toga smo razgovarali o zakonu o slobodnom pristupu informacijama, o transparentnosti, o tome koliko je zapravo potreban reformisani zakon, koliko je uopšte taj zakon jedan alat koji imamo u borbi protiv korupcije. I čuli smo međunarodne iskustva koja se također tiču.
Experiences regarding financing political parties. At the final panel, we talked about public procurement and corruption in public procurement, which is very field recognized as very susceptible to corruption. We'll have 3 panels today. We have the Minister of Finance and Social Welfare, Milojko Spanic. Sergej Sekulovic, Minister of Interior. In the first panel, we will talk about the reforms on confiscation of proceeds of crime. We'll hear the presentation of the law itself, how far the government has gone with this law. Then we'll talk about confiscation of property in criminal proceedings and criminalization of illicit enrichments of public officials. And in the end, we'll talk about civil forfeiture of criminal assets. Without further ado, I will give the floor to the Minister of Interior, Mr. Sekulovic. Good morning, everyone. Mr. Milovac, my colleague Spajic, and all of you in the room. I will, within this relatively short presentation, I will say something about the current affairs of the Ministry of the Interior. We will talk about the law. It's in the process of public debate, and the whole day will practically be grouped around it. It's in a way revolutionary, with all the challenges and risks and ambiguities that it opens. But we speak about confiscation now, which will not be linked to the final court judgment, which opens the room for results that we have lacked so far. Waiting for the final decisions, enforceable decisions, was a barrier, an obstacle to proceed with the confiscation of assets, especially in the cases where it is clear that there is a disbalance between the income of a physical person, let's say, and the property that person has. I will refer to something which is our priority in that field. These are the new aspects of the new law. We are about to finish the new job scheme of the Ministry of Interior. Within that, we will have anti-corruption unit. This unit, as its primary goal, has the intention to deal with the lifestyle of police officials. In the police, there are those who have salaries between 500 and 1,000 euro and who have millions in property. And that is something that the citizens of Montenegro find problematic and reduces the trust in the police itself, although it's been growing. In this extremely difficult year, we have managed to further develop the trust into the police. There is no ethnic distance in the police as well. But the fact is that most citizens of Montenegro think at this point that there is a high level of corruption in the police, and our primary goal will be to deal with the corrupted persons in the police and the Ministry of Interior. That's one side of our activities, where we will have the control within the anti-corruption unit that will deal with the living style of officials who will which will have the access to the declarations of property, and which will investigate in a way such cases. Other ministries will hopefully be able to catch up with us. What we are doing through the job scheme and what is necessary, we can see it, and that's the conclusion of the EU, that we have lack in human resources that should deal with this field. We have strengthened the organizational units dealing with commercial crime. We have noticed quite a lot of shortcomings, especially when it comes to corruption at a high level. We will also increase the capacities of the special police unit, which can maybe be interpreted as if we are strengthening the position of Katnic, the special state prosecutor. But we are not. We're strengthening the institutions. We will strengthen, we will empower all these units. This anti-corruption unit, owing to the new law, will have the competence to do initial and periodical polygraph investigations of all those who deal with organized crime and corruption, and those who reject polygraph will have to give their positions to others. So each new employee will undergo polygraph initially when they're employed, and then periodically, because we need to have trust in these people. In exchange, this state must provide proper salaries and also technical and every other assistance in their work. Each responsible state should support this system. If the system does not give results, ask the for the accountability of the Ministry of Interior and the police. But we need to build up the system. We think that we are now setting the healthy ground for our activities. At the end, for the sake of information, in the last year, we launched criminal proceedings against 33 persons from the Ministry of Interior. The goal is that when there is evidence, we proceed with that. When there is a political background, we have to deal with that. No political party will employ their people in the Ministry of Interior, or will cause problem in that sense. But if there is evidence that some people are corrupted, they will initiate criminal charges against them. We will definitely work on that more in the future, although we have already achieved some results. And to conclude, the new law in that context is an important tool. We have the Ministry of Interior, and I think that when we have the final drafts, there will be some improvements in the meantime. It brings some risks, undoubtedly, but as a system, we need to do our best to make it functional and implementable. Otherwise, we'll go 10 steps backwards. Because at this point, this government, any government, no matter who in power is, must have a clear task. These are measurable results, and the trust of the citizens of Montenegro in what we are doing. If we don't have it, we don't have anything. That's all from me for the beginning. Thank Minister Sekulic for this inspiring introductory speech. Now I would give the floor to the Minister of Finance and Social Welfare, Mr. Spajic, to tell us how we will return the money taken from citizens.
Pozvali na jedan ovakav event i mislim da je vrlo bitno da se čuje, da se čuju razni glasovi sa raznih strana i da imamo neku cjelokupniju sliku od one koje možda mi nekad imamo kao zatvoreno zvono unutar vlade i vrlo je bitno čuti i nevladni sektor, vrlo je bitno čuti i ostale stakeholdere unutar društva. Mi smo već 14. maja ove godine mi smo predali jedan zakon koji je tada, ja mislim, niko nije objavio.
Okay, there was a technical problem. Last year we made a draft of a law and sent it to the parliament. That's the law on undeclared assets. I'm sure that most of the MPs don't know about this law yet. The basic thing is that every undeclared asset above certain amount, above certain threshold, will be subject to taxes in the amount of 80%. There are several reasons for that. One of the reasons is that we shouldn't wait for the final judgment to confiscate assets or seize assets or use these assets for some other purposes. The second thing is that it serves as a deterrent for people who gain assets in millions, compared to those who can earn such large amounts through legal activities. So that's a warning for everyone, actually, that if even these who earn the money legally, if they do not declare that property, they will have to pay taxes in the amount of 80% of the assets. We first started with that law, and then we continued with the set of laws for the program Europe Now. Why? Because Europe Now, as a program, is structured in such a way that people cannot say that we take the money from people in terms of taxes. No, we have made a gradual scale. It's called in English tax wedge. These contributions are from 24% up to 35%. That's the maximal amount. That's the ceiling. And with that, we want to send the message that no matter whether they get minimal salaries or high salaries, they will have benefits from the program Europe Now. They will have a less burden for their work, on their work. And this hand that we have put to the citizens will shake the hand of those who do not want to use this opportunity and the goodwill of the state to declare all their assets.
That's one side of the story. The other side is the one that we heard when visiting Brussels at our latest visit. One of commissioners told us that the essence of chapters 23 and 24, now that they expect that the Ministry of Interior and Law Enforcement carry out their activities in this field, and that the judiciary has a final say. Whereas what they feel is that the backbone is the duty is to regularly pay tax, charges, duties, and to provide a system which operates to the full. This is where we see the power of the state. If you ask someone in the States, in Belgium, wherever, whether they fear police or tax police more, they would undoubtedly say it's financial or tax police they fear more. So this is that we have to make the efforts to deliver this first step, and this is just the first step, because I believe that that we'll have to dedicate to lots of issues that remain. We will have to combat the drug trafficking and else, and the police is there to do its duty. But tax and tax issues will be the essence of chapters 23, 24. The tax base too, and as such, together with the Ministry of Interior, we are going to jointly commit ourselves to become the state which will make sure to check how the wealth was created for each individuals, whether it was through drug trafficking or else, or from legal operations, legal business. So transparency is absolutely necessary, and everyone will have to report the assets, and then we are going to see, as the Ministry of Finance, to reclaim the unpaid tax, and then afterwards that party, so we would forfeit or confiscate the assets that can't be traced back to legal and legitimate businesses, whereas a person who cannot prove the origin of its wealth, of his or her wealth, will have possibility to prove that in a specific and discrete procedure, in a procedure before the court. Yeah, we will try to work together, to work in synchrony, to work in harmony, to actually to avoid competition between us, because there are some media speculations saying that that two ministries are competitive, that there is an atmosphere of competitiveness between us. I want to quash those speculations and say that we work in unity, in harmony, and that would be all for the introduction. I won't say more. I would be available for your questions. Let me say a couple of words from MANS as NGO who worked on the issues and which investigated issues on illegal and illegitimate enrichment. Hundreds of millions of euros were taken out from Montenegro. It is a very serious problem, and it is confirmed through our research, where we saw that at the very top of the country, personified in President Đukanović and his family, which created a complex international scheme through several countries to conceal illegally acquired money and financial assets, to hide it from the Ministry of Finance, from Ministry of Interior, from Tax Directorate, and to move it through several layers of concealment, and we managed to see through all of them and to prove the scheme is as such. So we see that the wealth and the assets of officials grows much more than their income. So we see that there are there is also the other way, the other direction of this process. So lots of money was brought into Montenegro, and our shore, our coastline, is recognized as the very image of what happened, of the fact that money, that Montenegro is a money laundering destination. Then instead of using the fact that instead of having them convicted, instead of having prosecuted those cases fully, we have ended up in the situation where we would have to pay damages against frozen and for the frozen property because the prosecution didn't manage to prove the case. So there are the law could be the good point of leave, good points from where to start. And we want to, it could be a basis from where to start to make the citizens get at least cosmic or the cosmic universal justice to have those money reclaimed. On the other side, apart from that, we don't have, on the other side, we don't have institutions efficient and unbiased enough so that we don't end up with in situations that it turns into witch hunt or else or some kind of vengeful exercise that we saw some 10 years ago. So Special Prosecutor's Office should have been more active, and they have so so that we don't end up in case where we have futile indictments and unfinished prosecutions. Realistic situation is that we have the fact that you have planned your activities within your mandates, but by a fight against corruption has unfortunately become the first victim of the political crisis, because this situation benefits only those who produce, who commit those offenses and engage in illegal practices, financial illegal practices. So what we had so far should never be repeated, be it during the mandate of this government or else. We should preempt this from ever happening again. We talked about political corruption, and after a year and a half of the new parliamentary majority, we have seen very few things that they pledged to do or that they declared to be doing. So we need to find the ways to find answers why how come Milo Djukanovic has 3 million euros, or how come that Pejovic could buy aluminium factory, and what was the arrangement like. So we don't have the anti-corruption procedures in place in order to create good grounds for not ending up in a situation that we saw through those 30 decades. So this law and the whole procedure, one shouldn't remain just a pre-election pledge, but instead the piece of legislation, the legislation that will help carry out the investigations. Are there questions from the audience? Nikola Đurović, I come from Prva. Can you tell us something about Deutsche Welle statement of Prime Minister that mafia is stronger than the state, and how come that you don't have policemen at the shores of the riverbanks of the Morača River to see that this is not the topic for discussion. You can do it afterwards during the break. How to reply to your question? I both agree and disagree with that statement. Yeah, there is a thin line between, there has been a thin line of divide between mafia and the police. According to the information, regarding the Morača exploitation, the Morača coast exploitation has been something that lasted for quite a while. Illegal exploitation lasted literally too long, but it takes not only the action of police. There are legal activities there are illegal activities, there are some concessions that were issued. There was excessive exploitation or normal exploitation, but it takes action, common action, joint action of both police and other ministries and Ministry of Interior and other ministries, together with prosecutors to investigate this case. What is important? So now the damage is too big, and I see that this team is working now. It is multi-sectoral team, and police is doing its share. And if there are suspicions against inactivity or omission of activity of any of our police officers, we'll deal immediately with that. And no one will be spared, no matter who and where they come from. And it is the issue that has been concealed and covered up for quite a while, and we are ready to address the issue and to undertake necessary activities for that. Yes, I'm here for any further questions you might have. If there are no questions, yeah, you have a question? Question for Minister of Finance. How do you believe you can get the information, given the fact that we have those databases available as we do, and how will you get track down the income that comes from abroad, or will you use international cooperation to track and detect those transfers, and how to make an access to non-resident accounts in Montenegro? Yes, I might omit some parts of your question, so remind me if I do. We have good cooperation with international financial institutions. We have one data, which is data warehouse building that we joined, and we want to make a solution.
Nije samo zbog ovog zakona, ima mnogo više.
A tool which will help us track down those transfers. We will have more transparent picture and presentation of those transfers. We'll have better data flow coming from the customs, from the tax office. We had a situation that our tax directorate had one databases, the other was of the customs directorate, but we managed to address this because we know that VAT collection system and others, we have to link these two. And the second step is to have the incomes and assets databases and cadasters connected, and cadastre is not the only register of assets and a register of property, but it's very important. We have to sort that out. We start with the state property. First of all, we have to address this issue because we don't have the full register of what state property is. By the end of March, we'll have the preliminary database of the state property. So we'll start with that. When we establish that, we will then try to make 1-6, and that is the private property, X being the state property, and the rest will be the private property. And then through the reform of cadastre and cadastral register, we'll manage to see who owns what. Through your investigations and research, you've come up with very important information about ID numbers that do not correspond to the people who are real owners of assets. There are lots of illogical things, and that is the weakest point in the Ministry of Finance or within its mandate or portfolio, if you wish. So what we need is an in-depth reform. This database will be connected with the others. So the balance situation, the state of balance will have to be connected to P&L part, which is the income part. And of course, we will also see the social security number, which is subliminal and which sublimes all the information, the income, the assets, the and why we have joined the social welfare, merged social welfare ministry with the Ministry of Finance was that through the social security number that would be given to each and every individual, we could then have an overview of the assets owned by each and every individual and into the material status of each and every individual. As for international cooperation, I want to say that we have signed in FATCA agreement with the United States of America, and we have agreements with many countries. So we talk to our partners, we have communication with them, and after the law is adopted, will be a serious state, not considered a banana state, but a state in which could be an equal partner to the countries which have developed a system of revenue and tax collection, and will be able in near future to make good bilateral agreements with the centers in London, Emirates, Singapore, and all sorts of Switzerland and financial institutions over there will use their information, their data, and our data are very important for them. In that exchange, I believe we'll come up with valuable information. As for the central bank, they'll have to be a part of reform, a very important part of the reform, because they are one of the few institutions that have all information about transfers, both those incoming and outgoing transfers. The reports that we can get is not comprehensive enough. Their report is not comprehensive enough for those who investigate corruption. So I believe that central bank will be more involved and work in cooperation with the Ministry of Finance and others. Sorry if I haven't replied to all your questions. There is another question. What about transparency of those information? What will be transparent for the tax collection for taxpayers and what it want? As for public officials, they have to declare their assets so how well it's done and how much we can trust of them when they declare the assets. I will publish and show my tax returns and notice of assessment that I have from Singapore, which tells you how much you have earned during the current year. And that information is the information that the tax directorate in Singapore tells us, for example, you earned this and you have to pay tax, and I will publish that document to, for example, explain the property and the origin of the property that I have. I do expect the same to be done by all public officials, present and former. It would be very interesting to see as the public how it works, and maybe it would encourage people to transparently show and present where they got their assets from. It would be a healing process, a very wholesome process for Montenegro, and maybe they would, in a way, quash our criticisms when we criticized someone for the property he or she owed and were suspicious of that, they could quash those suspicions and quell those suspicions by showing transparently how they've come up with it, with assets and with property. During the day, I might show that in the Twitter and via social networks. I'll show my tax return notice and assessment notice, so I would expect others to follow.
We don't hear. Do you think that the data and taxes paid by companies should be public? So far, they've been secret, although they submit financial statements, but they're not published. So if you want to see what is the difference between legal revenues and property, the institutions can hardly do the checks on their own. So I'm specifically interested to find out what is the amount of taxes that legal persons pay. I fully agree regarding public officials. I think it's a good idea, and I think it would be a good position. And so what you suggest is a tool to check whether they accurately declare their assets. As for legal persons, I agree with you. It's a good idea, but that's not the practice. There are a lot of states where it's not the practice. There are a lot of states where, Western states, where taxes are not public or not presented publicly. Of course, if there is any suspicion on tax evasion, there is a way to get those data, but whether it would be clever to publish the information, yes, I think it would, but I don't think that companies have a reason to hide anything. Companies on the stock exchange public companies is the name, and they should publish such information or disclose such information, so the investors should have a transparent insight into what they're investing. But the private companies and so on that are in private ownership, why is it important for the public to publish such information? I'm in favor, but I can also imagine that people will be against, so we should open a debate about that. Vanya doesn't have the microphone, so we don't get any sound for this question. We can certainly launch an initiative or a public debate. I think that all the data should be made available to the public. Before I give the floor to Mr. Sekulic, I have to use this opportunity to say something, because MANS has been using for a long time the example you mentioned, the state property, and I want to refer to the half a million of square meters which has been illegally used by the mayor of the municipality of Budva. And maybe if you're making the list or the register of all the state property, maybe you should also include that property in the list, in the register. Real estate agency and knows these things. But do you have the solution for this land? Because a mayor practically usurped this huge piece of land. I know it's attractive to mention some specific names, and well, you can mention another case of 500,000 square meters. I just want to say that any person, it's not, the name is not important, but any person that has acquired the property in an illegal way, that property should be seized and confiscated. There is no discussion about that. Of course, there is a procedure for that. We cannot act without legal procedure that needs to be undertaken. I will fully support such a procedure. There should be a specific procedure for that. Well, I don't know about every single procedure. I look into the system generally, and the people who carry out these procedures should not have any problems with politicians. No politician should prevent them from doing their job, and this thing should be brought to an end. Thank you. And we'll take this as your example. Now I give the floor to Minister Sekulic. In your introductory presentation, you mentioned that the whole system of fighting corruption, seizure and confiscation of illegal assets should not be done at the expense of human rights. It's the 10th of December, the Day of Human Rights, and we need to pay special attention to that issue. Respect of human rights within all these activities must be fully guaranteed. That's one thing, that's the responsibility of the state. And secondly, I wish to thank you for all the criticisms that you gave us, because without developing a critical mind, whether you like it or not, whether it's well-grounded or not grounded or half-grounded, but without the development of a critical thought, there is no development of the society. And thank you for your criticisms. And one more thing, we are in the final stage of developing the strategy for fighting transnational organized crime. And it implies networking of state bodies unseen so far, the bodies that deal with criminal activities, especially serious forms of crime, and cooperation with the external factors such as the civil society. We'll have the public debate about the draft. And I would be grateful if all the organization months, including which seriously deals with this issue, be our associates, but also our critics regarding this topic. If there are no more questions, I would conclude this introductory panel. We'll now have a short break just to sort out technical things for the next panel, where we'll speak about the proposed reform in this area. And thanks, ministers, for coming.
Dobro jutro svima. Počinjemo. Danas sam ovako dosta teško.
Let's start. It's been the topic that's been a burden for many years in the country, because we live in a society where the assets of public officials does not correspond to their income. The new government promised to put an end to it in a way, because financial investigations, the activity of the prosecutors haven't yielded results in that field. We are now discussing the proposed reform on confiscation of assets or confiscation of proceeds of crime. We have distinguished guest here, Boris Savic, President of the High Court in Podgorica, Boris Maric, State Secretary of the Ministry of Justice, Valentina Pavlicic, representative of Montenegro before the European Court of Human Rights. It's going to be interesting to hear how much this topic interferes with this corpus's rights and how it exposes you to us to some other damages. Then Vukosavjanovic, Sector for the Fight Against Crime from the Police Directorate, and Professor Nebojša Vučinić, former judge of the International Court of Justice in Strasbourg. So let's start from Mr. Maric, State Secretary from the Ministry of Justice. Let's hear what is the core of these amendments or changes, what you have had in mind, and let's start from that. Thanks, Mr. Komnenic. Thanks the organizers for invitation. I wish to warmly welcome you. More or less, we have managed to explain what is the idea, what is the intention, why we've chosen this model, which means amendments to the existing law on the confiscation of proceeds of crime. We are introducing the civil concept. We are introducing a REM system or institute. And of course, it would seize the proceeds of crime, irrespectively of the court proceedings that would follow. The procedure would go with the initiation, start with the initiation of the financial investigation. Financial investigation would largely take place in the institutions mentioned in the previous panel. These are Police Directorate, Tax Administration, Customs Administration, Anti-Corruption Agency when it comes to public officials. And we have to work on the strengthening of institutional strengthening of all these institutions, and we have to pay special attention to the institutional strengthening of prosecutors or prosecutor's office. We now have the system of financial investigations, but the model has been, or the results have been quite modest so far. We have the problem with the capacities in prosecutors' offices regarding financial investigations and establishing the financial team in the prosecutor's office. So no matter what the legal provisions are, the composition of the financial team will, at the beginning, show exact results or shortcomings if you don't have the proper financial investigation unit. How to form this unit, in addition to the institutions who should have representatives in this team, we would also have external experts, forensics, who can be also engaged in order to strengthen the capacities of the financial investigation team. On the other hand, we need to have good communication. It's an important element of the future results of the financial investigation team. So the prosecutor should understand that those who are in the financial team are his or her associates, and they're working on the same tack, that the prosecutor is not the general of the infantry to lead the way he or she thinks, or taking into account some personal relations. At this part, I would like to stop here. We will discuss it later. And there were a lot of questions regarding criminalization of enrichments of public officials. The threshold here was 50,000, is 50,000 euro. Why this threshold is 50,000 euro? These things are important. A criminalization of enrichment of public officials is under review, and it has to be incorporated into criminal code. Months earlier proposed incorporation of this in the criminal code, and I think we should work on that. The criminal code implies a comprehensive procedure regarding amendments and the expertise involved in that, because everything has to be harmonized. The amendments should be ready in the first quarter of next year, according to the government agenda. It was supposed to be completed by the end of this year, but it was really unrealistic because we don't know what will happen with the government after the new year. Well, yes, but then the next government can continue if that happens. But it will be of interest for everyone that the criminal code supports this law, that we need to amend the law on the prevention of corruption and strengthen the capacities of anti-corruption agency, and to come up with a law on the free access to information, which will be the logistics to this law as well. So there is a set of laws which are the legislative precondition for starting with further activities. What is the time frame? What do you say when about this threshold of 50,000? Is it too low? Can it be an obstruction to future investigation, or can be turned into a hunt on witches, and then everybody can be subject to financial investigation with very average income? When the law is implemented, of course there will be amendments. Its final intention is that we can check everyone, but in this part, the public interest is to focus on checking on all those who are critical. Of course, we will reconsider raising the threshold. This is the initial threshold, which was used in other states who started applying this model, and then it can be raised later, whether it will be 150 or 200,000 euro, 500,000. Well, you mentioned Britain, Germany. We consulted all of them. We had the expert support from all these countries. We have their opinions on our first draft. They have assessed it positively. As for the threshold, Slovenia has 50,000. Britain has 18,000 pounds. So their thresholds are quite low, because they have overcome the problem that we have. So that's why our thresholds are low. The law primarily focuses on organized crime and money laundering. And we have to pay attention to also illegal enrichment of public officials, because this is sine qua non of the whole process. We need to manage with that in order to legitimize the norm and law and the institutions, so that they can be credible to fight organized crime and corruption on a high level. Let's leave this point. Mr. Savic, President of the High Court, when we discussed the reforms, there were ideas that financial investigations have provided poor results, and there was more insistence on the institutes of plea bargain. which you also criticized, saying that the court has no possibility to do anything because these plea bargains had already been concluded before the case came to the court. So we can now hear the case of the story of Svetozar Marovic, who sends us political lessons from Belgrade. What do you think about the proposed amendments? What do you think about the current practice?
I want to thank you for inviting me, and as for this the topic, I'll approach it from the position of a practitioner. I'm the president of higher court, and I've tried those cases, and I decide about that. This law was adopted in 2015, and we have extended confiscation ever since. We didn't have anything new in the meantime from the side of legislation. We had some 20 cases for extended confiscation, which were banal ranged from banal in values up to the very valuable, high-valued ones. So what we had, I'm not maybe the best address to get the question on why not many more cases, but I want to say that this is very sensitive type of cases, and for extended confiscation, there is no brilliant track record anywhere in the world either. So we have the law that complies with Palermo and Declaration, and the 4212 also Declaration, and I want to say that it is a very complex issue everywhere and anywhere in the world. I wanted to say that to illustrate, to set the scene, to actually explain why this track record, and I don't want to be defensive by blaming it on anyone else. The total turnover of the illegal property, illegally acquired properties in billions of hundreds of billions of euros, even in the EU. And in the EU, they mentioned only to repatriate 1 million. Sorry, maybe the speaker said billion, I'm not sure. So this is 1%, to tell you the truth, on the average, so that the results are slim, even globally, let alone Montenegro. So we have double whammy. First of all, illegal proceeds, illegal property. On the other, we have to pay damages to Kalic and others because the court didn't prove they acquired their assets illegally. But that is why we have also a grain of doubts about Marovic, because you told us that no one of the prosecutors requested his arrest, and that is why now we can hear from him only from Belgrade, calling from Belgrade. So yeah, so the system where you come from totally frivolized the whole system. The problem is to implement. Who'll implement? Who'll enforce those rules? we had fantastic laws. We were never short of laws, but enactment and implementation zero, like zero accountability of judges, of prosecutors and others. If you allow me, let me continue. It's very easy to agree that the illegal proceeds should be taken away and illegal property should be seized. So that we have a broad consensus that we should amend the law. But first of all, we need a good law. You know that lots of good solutions were made on the basis of wrong steps. So maybe the public, the audience doesn't know it is the law that contains two totally different institutes, one extended confiscation and the other being the illegal property. So only for someone who is not a lawyer, this could be the same thing, whereas it's different targets, two different targets. So extended confiscation of illegal property has adopted the same structure that was spelled out in the previous law. And this system enables that the accused person is involved in a way in the process of investigation, and we have the option that if we don't manage to forfeit or seize, confiscate the property this way, then the tax directorate will have option to look into the assets and duties unpaid or concealed. So, as I said, this is a very new institute, instrument of the law, the extended confiscation in Article 113 of the Criminal Code remains the same. So so here it's not just about conviction. It's we have a working group working on the system, and this working group believes that due to the complexity of this task, we have to have someone or some constitutional expert on board. So there is a consensus that financial investigations are handled, are prosecuted and led by prosecutors. However, the work group believes that we should, in this system, have someone else in charge. And at this point, we believe that it would be the Agency for Protecting the State Interests of the State, who will handle the proceedings. So it's one issue. Let me go back to my initial question. So these solutions could be only contested by those who illegally acquired property. But I want to add, the people who protected them and covered up for them will also be against them, because there is reasonable suspicion that those who used to say that there was not even faintest suspicion in something, whereas it proved otherwise. We had a guy who had hundreds of thousands of illegal euros and was just under our eyes, and we didn't do a thing. Why should we need any law when we don't enforce it? So this is my question. Should we then clean up the ranks and of those who have disturbed the process, who who are not ready to come to grips with that. And I believe that all prosecutors got the highest grades. The same goes with judges. I'm against cleanup. I'm for individual accountability. This is what I'm saying. Yeah, if anyone, whoever, policeman, prosecutor, judge, is to blame for something, we should have individual blame assigned, charged against that person. How then do you explain that we have no single case of judicial accountability? So you ask a judge why there were no prosecutions. It is the question you should ask. The question should be asked to prosecutor. Just imagine a system where the plea bargain, the court has to just rubber stamp and that your hands are tied. Just imagine we have former top official Svetozar Marovic laughing like crazy from his home in Belgrade. I have no dilemma about plea bargain. Plea bargain is an institute that was introduced by law, and the courts have to respect that, to apply this institute. The court cannot change the plea bargain contents. We can either accept or turn it down. So we can't touch a thing from that plea bargain agreement. So you keep mentioning Marovic in the context of that time when the plea bargain was concluded with him. We were for the first time we had for the first time a top official who got who made a plea bargain agreement in exchange for a prison sentence. What was important from that agreement was that he promised to return the stolen property. So we want to have restorative and not retributive justice. We can't have him back, let alone the property. We managed to return the property, but we can't return him. This is the question that is beyond Montenegro. We don't know how he left Montenegro at all. This is our concern, and we are to blame. How come that you failed to do that and he didn't end up in jail? So this was all a ping pong game, and before we do that, I believe we'll have lots of compensations to pay to those criminals. No, we didn't depart from topic. I believe we are hitting the target. There is a risk that such solutions turn out to be inappropriate. How do you see the key issues? What is, in principle, your opinion about this? So, first of all, as someone who was a judge and now an agent of Montenegro before the court in Strasbourg, I took part in public consultations that ministry organized related to the proposal of the draft of this law. And I want to say that so it's been 6 and 7 years now that I'm now looking from the other perspective into the others, our system, and I'm aware of its loopholes. And you have a former judge of the court with us, and you will see how the court in Strasbourg look upon us when we try to defend a case before the law. So this is not the new law. It is innovated law. It is, and I remember when it all started, I was the judge at the time. We had only one case where I applied that law at the time, and then I left the office. I want to say that the biggest problem with our system is corruption and organized crime, and that was one of the motives why the legislator decided to broaden the scope of the law by inserting new and extended prosecution. Italy and Netherlands, like continental systems, recognize the need to have this system in place because they couldn't handle the prosecution of some illegal offenders or otherwise. And then we come to the implementation and enforcement. Do we have, first of all, educated, professional, competent, and legally educated, well-educated prosecutors and judges who will be able to interpret this law in the spirit of European standards? So we as of the first moment we started implementation of the law, they said that had fears that the human rights would be affected, and that is to say that these people do not understand the system. In them, procedure is not not a procedure against an individual, but against assets or properties. It is against assets. What are the assets? It is the property which can't be proved to belong to someone. If it belongs to you, then it should then the target those activities be the assets related to judicial officials as well? Should it be the first step? So when I say, when you said the lack of education, so do you think that first they should first clean the judiciary as such? I will just limit myself to what I know, and that is how the European Court looked at Georgian, Italian, English cases of this kind. They never established any human rights infringement, but they entitled the state to create a distinction between documented property and the assets whose origin could not be proven. So the amendments of the law should integrate the recommendations and the standards ensuing from those court judgments. So I won't name the names. I just want to send a message. We talk about independence, and we keep talking about independence of judiciary. One independence is one side, the other is accountability. Why am I emphasizing that? The proceedings that reached the court was we had one serious criminal offense in the field of criminal commercial law. In the first and second instance decisions, €1 million was taken away from an offender who didn't report the tax to the state. And I'm talking about that because I was a judge at the time, and it became enforceable, it became final, it was double bookkeeping system. Do you know what happened with the sanction? The sanction came under the statutory limitation. So this is a question for the Judicial Council. Are those bodies competent enough to handle that? We actually managed to let the sanction come under statutory limitation by someone using and abusing the system to excuse him or herself from coming to the to serve the sentence, and there is no statutory limitation when it comes to criminal sanction, and we had totally wrong position about that. So who should do that? The Judicial Council or else? I won't name the names. I'll speak. I'll use the names. Yes, I also want to speak about it. We had the chief state prosecutor who at the time looked into did the preliminary legislation and dismissed the case of recording. That was the recorded case of political corruption. So how could the cleanup be done? I won't say the cleanup, I would say the reform. We need a reform so that every individual who is in the system should have individual responsibility. We can't accept to to end up in a situation that we want to reform judiciary. What do we get from that unless we do the reform of judiciary as well? So we managed before the European Court for Human Rights to win the case for efficient legal remedy, and we managed to make it more efficient. But what happened? We went 10 years. There is a slide back for 10 years, like 10 years back, and so. There are so many unfinished cases. Have we ever analyzed? Have we ever analyzed the causes? Are we happy with a situation where the pretrial detention expires and the investigation is not finished? So that is why these provisions should not lend themselves to those abuses. I gave suggestions to the Ministry of Justice with a financial investigation that is something that should not be done like for the territory of Montenegro. They have the Guardia di Finanza has different organization. They have support of a serious institution. So we don't have just one institution in charge. So when one institution finishes and investigates the same, we speak about suspicion or reasonable suspicion. Then if there is any suspicion, doesn't matter which one should go after that. Should we wait for that? So unless this system is ready to implement this in principle, good idea, good system will remain idle or useless. So like this case that I mentioned, This law has to affect everyone. However, adopting it, we don't want to have affect someone who bought a flat of 45 square meters and cannot prove how he managed to collect the money, whereas some big shot remains, gets away without any sanction just because of that. We still, and we are members of Moneyval, and we don't have the final rulings or adjudications in those cases, just two trivial ones, because the application of the norms is not is more verbal, linguistic than interpretation by standards, so articulated, spelled out, and inaugurated by the court. So if the statutory limitation for those cases of confiscation is extended, I'm not happy with what Minister of Finance said, in his claims. If we make a mistake, then the state will have to foot the bill, and it'll be enormous. Let us go on. How the representative of the directorate, how ready are we to act? For years, we've been talking about police officials whose property exceeds their income. We saw their vehicles, we saw their clothes, their houses, and so on. It's colloquial, but how often had it inspired or initiated any good investigation?
In the police directorate, or the Ministry of Interior, and police directorate is a part of it, there is an internal control department. That's why I'm asking this. Based on what the minister said at the beginning, that there will be the unit that will deal with these issues. I want to say that we look forward to that, because there will be a new job scheme, new positions, and people who will come to the police directorate, so that we can try to somehow sort out people. There is a vast majority of police officers who do their job in accordance with the law and the beliefs that they want to help. And they show extreme will and enthusiasm despite low salaries. So they don't have the financial motivation, but they're still interested in doing things. Are you encouraged that this story will succeed? What will happen with those people who have been exposed to corruption? Will they be just downgraded and remain in the ministry and work there till they're retired? Exactly. This law, if it is adopted in this draft that we are talking about, will leave room to clean up things and people, and so that we don't have the situation, you don't hold a position, high position, you will be downgraded to another position. No, we will have to expose these people to prove that they have not gained their assets in an illegal way. Do you know how to do that? Is it just a question of goodwill? You need to have the expertise, you need to have the knowledge. For years we haven't trained people to deal with these kinds of investigations. Those who hid their money, who invested a lot of money to still there. Do you know what you're dealing with? We're absolutely aware of all the shortcomings, but we are also aware of what we want to achieve in the forthcoming period. I will again mention what the minister said at the beginning. The unit that he mentioned, the Ministry of Interior has within its organization the police directorate. We are now dealing with the new job scheme. We have recognized the problems, and the financial investigations have been carried based on the current law. But what can be the problem in the implementation of future solutions is something that we have dealt with. And there are people, definitely people who can work in this area. So have you already undertaken that training or something? Yes, we are having trainings, and we plan additional trainings. For the time being, we have a lower number of people who will specifically deal with financial investigations, in most complex cases in full capacity. But we plan to extend these capacities. In what way? I'm just going to say, in the sector for fighting crime, we will establish a group that will be specialized for financial investigations. We will have experienced people who have carried out financial investigations so far, then also younger people. Who are these experienced people who have carried out financial investigations? Especially bearing in mind that these investigations have provided very poor results. Or are there some people that you cannot count on? Definitely, we have such people, but they are just few. What was the constituent part of your question was encouragement, and that's what we currently have. All those people who will be in charge of these activities must be encouraged. So, in addition to the will to do that, and encouragement for their activities, what we plan with the new job scheme is introduction of people with special knowledge and skills in the field of banking, insurance, and so on, so that they can compensate for the lack of staff that we will need in the future in the field of fighting corruption, fighting money laundering, serious forms of economic crime, and carrying out financial investigation. So we'll bring these people in order to compensate for the people that we lack at this point. And we will, in the law, we defined establishment of financial investigation teams, which is a very strong tool in the implementation of this law. But we also plan within the ministry, within the police directorate, in terms of classical investigation, criminal investigations, we will also involve people who will deal with financial investigations. So that people, if they don't, so the people who deal with classical criminalistic investigations of cases that are not directly linked to funds, it could be the case of drugs, organized crime, and so on. So these people with financial skills will help them to recognize the elements of financial crime. So they will have the combined teams because in classical investigation, very often we lose the important data that can be crucial for financial investigations. They remain in the files and they do not reach the people who deal with financial investigations. So we plan to develop a case management system that will ensure that the managers and those responsible for some investigations will monitor the development of the case, and there won't be any obstacles in the activities, and also that we can meet the deadlines. On the other hand, as the management, we will have an important tool to identify the assets that the people who are subject to financial investigation hide behind third persons. So, for example, a police officer controls one person in a luxurious car that he or she does not own. That should be a red flag to pay attention to that, so that we can check whether the person against whom we are carrying out financial investigation has the assets that we don't know of. We have another element, the assets or the property that people have abroad. That can be checked by our office that helps us, that we know the owner of the assets, or another, whether that's that person or another person, we can identify it abroad and enable the prosecutor's office to get the data, the information as soon as possible. That's the political part of the story. Let's come to the former judge of the International Court of Human Rights, European Court of Human Rights, sorry. Thank you for the invitation. I want to welcome this initiative of months. I expressed my opinion in the program that we had recently. Boris was there as well on TV. I must apologize, I didn't participate in the public debate. On the 17th of November, I was in Italy at the time regarding the Convention on the Status of National Minorities. So I just speak based on what we discussed in the TV show. I will just give you a historical point. We had a similar initiative in the 70s, at the time of communism. It was called You Have a House, so Return Your Flat. And there was checking of the origin of your assets. There were party commissions that made some decisions. And then it came to the Supreme Court. The head of the Supreme Court, or the president of the court, was one of our best lawyers, Mr. Stojan Djuranovic. The Supreme Court repealed all that. It was also done by the Supreme Court of the Yugoslav republics. And it all resulted in the famous statement of lifelong president of Yugoslavia, Tito. That was the meeting of the Central Committee when he said, do these judges have to blindly stick to the law? Referring to what the Supreme Court said. Fortunately, the European Court of Human Rights blindly sticks to the law. And the case law shows that uses the test, and when the first test is the test of legality, when there is the interference at stake. So whether the interference is based on law, in terms of the rule of law, not the formal legal concept of the law. in a famous case, the European Court says the following: Malone versus the UK. It refers to wiretapping. What they say, what is the law and what the law should be like in order to meet the criteria of lawfulness in terms of the case law of the European Court and the rule of law. It would be contrary to the rule of law if discretionary rights given to the executive power is given as an uncontrolled power. It turns out that the law must clearly point to the limits of such a discretionary freedom given to the competent bodies and the manner it is used, bearing in mind the legal goal of a measure in order to give an individual appropriate protection against arbitrary interference. So we are speaking here about amendments to the law. According to our constitution, retroactive application of the law is not allowed. There can be just some provisions that can have a retroactive effect. That's Article 147 of the Montenegrin constitution. So when speaking about this law, it refers, or it endangers, not violates, but maybe endangers the application of this practice can put into question Article 6, Article 7, which is also considered part of Article 6, and Article 1, Protocol 1 of the Convention. So a wide set of human rights. And then this law must be extremely precise, accurate. What does it mean? It shouldn't allow any wide interpretations, any abuses in practice. From this Malone case can be said that the law cannot give authorizations that can be interpreted as uncontrolled, arbitrary power. The law must precisely define who is it applied to, how it is applied, within which time period it is applied. That's one of the crucial things. It will go to the Constitutional Court for discussion because the court, this law in Slovenia was revoked. So this is a sui generis procedure, including civil proceedings, criminal proceedings. So it's a specific new thing. As a judge, I participated in at least 3 or 4 cases when we discussed UK legislation. Some mafia guys complained of the confiscation of their assets. And at the beginning, we said the applications were inadmissible, but later the law must be precise. We mustn't allow adoption of the law which would be arbitrary, which allow arbitrary decisions. We must refrain from that. We must also refrain from political abuses. Every law is applied in a specific political, cultural, ideological context. And the European Court also takes into account that context. And we need to take into account the existing context. We must pay attention to how the law will be applied and against whom it will be applied. We also, the burden of proof or transferring the burden of proof is not an unknown institute. In some situations, the burden of proof can be transferred from the prosecutor to the plaintiff. But as a balance or counterbalance, we need to have the so-called additional safeguards from Article 6 or the safeguards of the fairness of the proceedings. So additional guarantees against this arbitrary abuse of power. So my personal opinion is that all the activities of the prosecutor, because the prosecutor conducts the investigation, it's the special prosecutor. We not need to have the special financial unit in the special prosecutor's office. Not, I know 2 prosecutors in Montenegro who can do financial investigations. Maybe there's some more, but I know only 2. So this must be done by the special police team in the prosecutor's office. And I think that this defender that is mentioned in our law means that we in advance say that it is state property. So we must have safeguards. What all the decisions, all the acts adopted during the investigation must be under the control of the court. The final decision on launching the proceedings after the investigation is completed must be made by the court. If that does not happen, we will fail in Strasbourg. I know how we analyze the UK laws. These are the additional safeguards, as they say in the court, safeguards. So the burden of proof is on the plaintiff, but there are additional guarantees that there won't be any abuses. In any case, there is another issue of the readiness of our courts and prosecutors' offices to apply this law without abuses and to become just a blank paper. So if the proceedings is launched and there was no ground for that, there has to be a compensation of damages as well defined in the law, because here we apply law on civil proceedings, the law on criminal proceedings, so we have to bear that in mind. The main issue here is the issue of retroactive approach and predictability. These issues will be definitely discussed by the Constitutional Court. But the concept of Article 7 is not a formal prohibition of retroactive approach. It's just the ability of the one who is subject to predict whether someone's behavior in the future will be subject to criminal sanctions. Of course, those who deal with trafficking in drugs must be aware that such behavior will result in criminal liability. But that must be precisely defined in the law. And we must clearly say when the application of the law starts. We may say the law can be applied for the period of the last 30 years. Is it a long period? Because then you here shake the foundations of the legal certainty. That's one of the most subtle issues that need to be taken into consideration. What time period should be taken? I'm not absolutely against retroactive application of some provisions of the law, especially the way the European Court interprets retroactive approach in terms of predictability, but we need to be very cautious. Peter doesn't have the microphone. We started with the best things that we could provide at this point in terms of experts and in terms of the functioning of the system. Is it enough? Well, I will say whether it's enough or not. We have compensated that with external and internal experts. We never thought of discussing it without bearing in mind the possibility of engaging experts. It would be contradictory to speak about a lack of staff or lack of institutional capacities and then claim that we are doing a great job. So we have had wide consultations and we have engaged quite a lot of experts. As for a retroactive approach, this law will be applied as of 2015. So we are here dealing with amendments. Of course, initiating the proceedings must imply that there is reasonable ground. What does it mean if you start from 2015? We've done a lot. We have resolved a part of the retroactive approach. The second part is that if there is a preliminary investigation open, then we can do it retroactively for the previous 5 years. It is a significant period allowing us to look into the assets. The thing is that this does not refer to the assets. If we have serious financial investigative teams, and our colleague explained what we are planning to do, ministers, especially the Minister of Finance, explained what we're planning to do, then there will be huge the contribution of the whole initiative, because they're practically exerting good pressure to accelerate things. The institutions cannot do it at that pace that people expect them to do. But as for this law, it is we didn't hear the question again. Microphone is off. So we don't have the possibility, bearing in mind the resources, to interfere into each other's affairs. So, and the amount of taxes that will be paid is something that will be considered by the Constitutional Court. There are few risks regarding potential unconstitutionality. We are still working on some details that at some point in time will be harmonized. I have another concern that we have talked about, and Peter mentioned it, and that is how we can quickly find the staff to carry this out. These people will need to have two elements. We have done trainings and harmonization with the European practice, but it could not function because we don't have two elements. That's professional ethics. That's why ethical committees in the prosecutorial and judicial council do not work. And then analytics, because things must imply good analytical approach. Without these two things, without these two components, we cannot do much, and these are necessary for the prosecutorial and judicial aspects.
Any questions, or we should wrap it up? At this panel, are there any concrete questions? Tanya, you have the floor. Microphone, please. Will the law be applied only to the cases from 2015 on, or it will be retroactively applied? So what will be the plan for application? Because Sorry, we have terrible problem with the sound. So yeah, there is the first million of the president that should be looked at. So is it possible to have the longer period of application of this law, meaning that it could cover the date before? So yeah, and yeah, this law covers all the illegal property. So if there is a public interest, I believe that we could argue for retroactive implementation of the law. So we expect that we believe that because this is definitely in public interest, so that it should enable longer application of this law. Let me take this question, and then Mr. Savic and Pavlicic might follow up. So this is a complicated term. 2015 on, this period is already covered. Slovenians started in criminal legal terms to actually apply it from 1991, since they went independent, and the Constitutional Court overruled it. What we actually managed is that we could examine the assets in general, meaning in general, universally. So these two offenses, organized crime and high corruption, high-level corruption, they never they can't come under statutory limitations. We can't hear the question from the audience, sorry. So if you want to initiate proceedings, you are led by reasonable doubt. So organized corruption is a part of organized crime, as a form of organized crime, and we believe that this law, when applied, and will be targeted against organized crime, definitely. So we have a mechanism in place. So whether we'll deal with the abuses that Professor mentioned, we see the abuses now, because prosecutors have serious mechanisms at hand that could be abused, but the court should be in control, since the court controls the prosecutors who abuse the secret surveillance measures, then it ended up without any responsibility determined and established. So we European partners have problems. They know that also they also know that the state has to have stronger systems to fight corruption, but this model gives this possibility, together with a set of laws that should strengthen and improve logistics, that should have a final results. We need we could apply the goodwill primarily. If we have prosecutors and policemen who want, and tax inspectors who want to investigate those cases, they'll have a mechanism. They also had mechanisms before. However, there was the lack of goodwill. I suggest that if you have time, and if you can afford, we should follow up and let you pick it up from here. Yeah. We So public speaks about retroactivity and retroactive application. So what is important? We have to distinguish between criminal proceedings and the civil proceedings. When it comes to extended confiscation and financial investigation, everything could be treated in continuity. If someone acquired property illegally 30 years ago, why should we wait, and why have we waited for too long? Then it's really a long time, and but criminal offenses and criminal code named differently, the same institutes. So if you find this, the title of the article changed, then the judge says, oh, I can't apply it. It was not the same criminal offense, and so on and so forth, even though the article remained the same. This is what I stubbornly repeat to my colleagues. Please interpret the law in systematic and legalistic way, not linguistic one. So we have to decide whether we need a law or not. So when we have the law in place, the court will look at the time and when the law was adopted. If at the time the purpose of that was to fight against criminal high-level corruption. There is Gavanadze versus Georgia. There was a former minister who acquired illegal property, and he invoked Article 6 and protection of property as well, but they just turned him down bluntly because all reports that were made for Georgia were actually clear that there was a high-level corruption in Georgia, and they were clear about why Georgia adopted that law as such. So it is not about retroactivity for us. It is a civil procedure. Who is going to try the case? I'll be. What if we have a case against you, and if I say I got the money from as a wedding gift? But then the judge should come to judge this statement as incriminatory immediately, and he should turn down the argument because. So this is where the power stems. This is we should have in mind the powers we are given as judges and prosecutors. So I think that we should apply the law accordingly, and that it is applied and used by trained and competent institutions. Public interest. Microphone. We have to, that is why we need to fully explain and give rationale for adopting the law, because in the preamble of the law, we state clearly what public interest is. That is why I believe that the law could be used appropriately with or without amendments. If you can spare some time, we would love you to stay. We would like you to stay here. However, we are going to have on board our colleagues who have long experience in fighting against corruption. We can't hear the speaker, I'm afraid. Let's hear from Marco Del Gaudio, who will speak about confiscation of criminal proceeds. Sorry, we have a problem with the sound now. Did we manage to make connection? Is connection okay? I understand. Yeah, they are making some logistical arrangements right now.
Dakle, sa nama je Marco Del Gaudio, zamjenik nacionalnog tužioca za borbu protiv mafije i terorizma, koji će govoriti o italijanskom modelu konfiskacije prihoda stečenih kriminalnim aktivnostima, posebno protiv organiziranog kriminala, koji se može primijeniti na zločine počinjene od strane javnih službenika protiv javne uprave. Napominjem da Del Gaudio...
We will have to leave us. Mr. Gaudi, you have the floor.
Sì, la sento, buongiorno.
Dobar dan, gospodine Del Gaudio.
Bene, allora buongiorno a tutti dunque, come saprete sono Marco Del Gaudio della Direzione Nazionale Antimafia e Antiterrorismo. Ringrazio molto gli organizzatori per avermi coinvolto in questo meeting. Sono molto dispiaciuto di non poter partecipare a tutti i lavori, ma avevo un precedente impegno che non mi è riuscito di rinviare. Vi domanderete come mai in realtà un magistrato, un pubblico ministero, un prosecutor della Direzione Nazionale Antimafia sia stato in realtà coinvolto per discutere con voi di corruzione e ovviamente della confisca dei proventi del reato secondo il sistema italiano. È una domanda giusta, ma è una domanda che per me è abbastanza semplice da considerare. In realtà negli ultimi anni noi abbiamo assistito ad una sostituzione continua delle forme più eclatanti di violenza attuate dalle criminalità organizzate per controllare il territorio, una sostituzione degli atti di violenza con atti di corruzione, sulla base della circostanza che evidentemente si governa molto meglio il territorio e è possibile ottenere le risorse pubbliche attraverso gli appalti pubblici che vengono attribuiti nel nostro paese, si governa molto più semplicemente con la corruzione, cercando cioè di portare dalla propria parte i pubblici ufficiali e inserirli in una gestione delle risorse complessiva che viene effettuata dalla criminalità organizzata piuttosto che con la violenza. Le organizzazioni criminali io posso soltanto avvicinarmi, in effetti, ecco, va bene, è meglio? Dunque dicevo, abbiamo assistito in Italia ad una sostituzione sostanzialmente delle attività più violente della criminalità organizzata con una gestione invece delle risorse sul territorio effettuate attraverso gli strumenti della corruzione. Già molti anni fa il collaboratore di giustizia di Cosa Nostra, Angelo Simino, ci spiegò il cosiddetto metodo del tavolino, ossia il fatto che la criminalità organizzata, in quel caso si trattava di Cosa Nostra, ma la stessa attività viene compiuta dalla camorra napoletana o dall''ndrangheta calabrese e dalle altre forme di mafia presenti sul nostro territorio, hanno sostituito la possibilità di ottenere gli appalti con la violenza, cioè allontanando per esempio con la forza i concorrenti dalle gare pubbliche, i concorrenti sgraditi, hanno sostituito questa possibilità con la gestione delle risorse pubbliche attraverso un controllo da parte della criminalità organizzata degli arricchimenti che derivano dalla pubblica amministrazione. In che modo? La mafia si è sempre più proposta come un corpo intermedio, cioè una stanza di compensazione in cui gestire le pretese degli imprenditori di ottenere risorse da parte della pubblica amministrazione, la necessità per alcuni esponenti corrotti della pubblica amministrazione di ottenere il prezzo della corruzione per l'attribuzione di questi appalti e la possibilità per Cosa Nostra, per la Camorra, per l''ndrangheta di ottenere l'attribuzione di queste risorse piazzando negli appalti più lucrosi gli imprenditori appartenenti alla propria organizzazione o comunque quelli a cui dare il proprio favore. In questo modo evidentemente la corruzione è diventata un anello importante nella gestione del territorio e delle risorse. La corruzione è diventata cioè lo strumento attraverso il quale la mafia, attraverso le organizzazioni criminali di tipo mafioso, riescono a gestire il consenso da parte per esempio delle attività imprenditoriali e riescono a gestire la possibilità di ottenere risorse da parte della pubblica amministrazione, riescono a ottenere anche una sorta di welfare per il territorio sul quale operano, perché a questi imprenditori viene spesso richiesto per esempio di assumere soggetti che si rivolgono a Cosa Nostra, alla mafia o alla Camorra per essere assunti all'interno delle proprie imprese. E queste imprese sono evidentemente ben disponibili ad entrare nel gioco e a fornire il supporto perché la criminalità organizzata possa ottenere appalti lucrosi da distribuire poi agli affiliati. Questo settore dunque ha la necessità di, come evidentemente è stato importante per il contrastare le mafie nella loro manifestazione più violenta, ottenere gli strumenti diciamo, di repressione e di controllo particolarmente utili, come per esempio il sistema della collaborazione con la giustizia o la detenzione al carcere speciale, di cui è l'articolo 41 bis del nostro ordinamento, il cosiddetto carcere duro, anche se in realtà si tratta più che altro di un carcere che impedisce ai esponenti di rilievo dei gruppi criminali di continuare a comandare dal carcere. Dico, come è stato necessario munirsi di strumenti giuridici per quanto riguardava le manifestazioni più eclatanti di violenza, così è stato necessario munirsi di strumenti particolarmente efficaci per contrastare la criminalità organizzata da un punto di vista patrimoniale. E ovviamente se la corruzione rappresenta uno degli strumenti di arricchimento più importanti, è stato importante utilizzare nel nostro diciamo, ordinamento strumenti che consentissero di aggredire patrimonialmente, da un punto di vista patrimoniale, sia le organizzazioni criminali, sia i soggetti che con queste organizzazioni criminali fanno affari e i soggetti corrotti all'interno della pubblica amministrazione. Pensate che in alcuni territori, ovviamente non parlo necessariamente dei comuni più grandi, ma pensate a tanti piccoli comuni anche della provincia italiana, che pure sono centri di spesa importanti per le risorse pubbliche. Pensate come la criminalità organizzata è riuscita talvolta a inserire all'interno della pubblica amministrazione, dei consigli comunali o della struttura burocratica degli enti pubblici, è riuscita a inserire dei propri affiliati o soggetti che comunque rispondevano alle proprie o rispondono alle proprie indicazioni. Qual è questo strumento? Lo strumento nasce, ed è la confisca essenzialmente dei proventi delittuosi, nasce con queste caratteristiche che vi spiegherò, cerco di essere il più breve possibile, nasce ovviamente soprattutto per i reati di mafia ed è una confisca che si fonda su un criterio particolarmente rilevante, cioè direi un allontanamento del cosiddetto requisito della pertinenzialità, cioè del fatto che le somme di denaro che possono essere sottoposte a confisca siano proprio quelle stesse somme di denaro, quegli arricchimenti che sono il prezzo del reato di corruzione o il prezzo del reato di associazione.
There was a technical problem, so we have just managed to deal with it. Now I hope that you can understand the English translation.
Un problema per la traduzione.
Znaš šta ću sad uradi?
Fermo un attimo. Ma ti figuri, capisco perfettamente.
Može samo jedna kratka proba. Igore, molim ti, kaži nešto na engleskom jeziku. Samo da vidimo da li to ide gdje treba.
Dicevo, dunque, lo strumento principale che è stato congegnato dalla legislazione italiana è stata la confisca e ovviamente nella fase delle indagini preliminari il sequestro che poi consentirà al momento del dibattimento e della chiusura del processo la confisca definitiva. Confisca che però ha delle caratteristiche particolari. Nasce questo strumento sostanzialmente con la legge del 1991, 356, 91 poi diciamo modificata nel 92, in realtà che segue, è uno dei primi interventi che viene effettuato dopo le stragi della mafia nei confronti proprio dei magistrati che si impegnavano maggiormente nel contrastare. Parlo ovviamente delle stragi di Capaci e di Via D'Amelio relative ai colleghi Falcone e Borsellino. Qual è il punto centrale di questo tipo di confisca? E cioè staccare la possibilità di procedere a confisca degli arricchimenti che sono intervenuti per effetto della partecipazione alle associazioni mafiose dal reato che è stato commesso. È ovviamente importante che sia stato commesso un reato e che questo reato abbia realizzato una somma di denaro o un arricchimento, anche in termini evidentemente non di denaro liquido, ma la confisca e il sequestro potranno intervenire anche sull'equivalente, sull'arricchimento equivalente rispetto a quello ottenuto con la somma, con il reato commesso. Questo significa che non è necessario sottoporre a confisca esattamente il prezzo di quel reato, esattamente quell'immobile per esempio acquistato attraverso il prezzo della corruzione o ottenuto attraverso una estorsione, ma è possibile sottoporre il valore patrimoniale corrispondente procurato nel patrimonio del soggetto che viene indagato anche se appunto è scisso dalla realizzazione immediata del reato. Questo tipo di rivoluzione, perché prima in Italia, ai sensi dell'articolo 240 del nostro codice penale, era sempre necessario che il sequestro e la confisca intervenissero esattamente sul valore patrimoniale, sul denaro, sul bene mobile, sul bene immobile che era stato oggetto, diciamo, del reato. Ma con questa invece modificazione si apre la strada, diciamo, ad una idea della confisca che riguardi esattamente il valore. Consapevole del fatto che mentre la criminalità organizzata, ma devo dire anche i pubblici ufficiali, sono disponibili qualche volta a soffrire le pene del carcere, sono molto meno disponibili a perdere invece il patrimonio accumulato illecitamente. In questo modo poi in Italia sono state ampiamente utilizzate anche le cosiddette misure di prevenzione e poi evidentemente la confisca cosiddetta che noi chiamiamo confisca allargata, una confisca appunto che riguarda l'intero patrimonio del soggetto. Qual è il
concept of extended confiscation? What are the presumptions to have this confiscation? to make distinction between the how to make a good assessment, how to confiscate the property, and whether the property of a suspect is disproportionate to his income. This could be checked according to the tax returns that every citizen files, compared to the effective possibility of that person to make an income. If it take into consideration an entrepreneur or someone else's case. So this refers to public officials and officials who accumulated wealth that is not proportionate to his or her official income.
Nella consapevolezza che è uno strumento che consente di fronteggiare efficacemente.
Sorry, we had a problem with the sound, so that is why we are interrupting the smooth interpretation. Medo, ja prevodim, stavila sam telefon pod jasne prevodi. Ili problem? Ja prevodim. Aj, čao. Sorry, I'm on again. This is rather stressful, but we'll pick it up from here. So we can apply the same system on legal entities, companies, associations, and so forth that acquired assets and property through offending. So some criminal organizations or connections with the criminal organizations helped some companies acquire wealth, and this could be investigated by application of this system. If a company uses corruption to get a tender, to win a bid, then the Italian system is very good. The system applying to entities, business entities, because we consider it a criminal offense. But if it is not a physical person, we can't arrest a legal entity. And that is why then we can seize the assets. And that is why we establish whether a company, just like a physical person, legal entity, acquired wealth through criminal offense. This is very complex subject matter because the prosecutor has to prove that. To prove that when it comes to commercial growth of and enrichment of them, we could prove that they acquired that in relation to offending, committing criminal offense. So So how we go about it? I would say that we've made a cultural revolution in Italy with this instrument, especially from the beginning of 21st century. From 2000 on, the investigations changed. We were clear then that the classical investigation wouldn't be enough. It wasn't enough to apply just classical instruments to go after a criminal who's into hiding and whose property is concealed. So the classical investigations didn't enable that. We didn't prove efficient in proving disproportionate wealth, no matter whether it's physical or legal person. We are after classical investigations were classical police-led investigations. And what we understood is that we should look into finances, financial flows, and the shares in company, then go after beneficial owners and try to get those information. In classical investigations, you couldn't get this information. So that in Italy, at least in big prosecutorial offices, and I have experience in Napoli, concretely where I used to work, and before I joined the National Directorate in Palermo, we started with investigations running on two tracks. So when the prosecutor started an investigation against some classical mafia organization through wiretapping, seizure of documents, and through statements of witnesses and others, we would look into investments. If we are aware that there were some investments made by the person, we understood that it could be money laundering because they tried to legalize money. In classical investigations, would come up with that information. We would start parallel investigation conducted by financial police, who are specialists, who have expertise and technical knowledge to understand those processes and to start parallel investigation in order to fight against the crime also from financial angle, in order to detect and prosecute all kinds of predicate offenses like drug smuggling and else. So we worked side by side with financial police. So if we have people who work in the system and they supply information and influence and act as mediators to those criminals, so we would also conduct parallel prosecutorial investigation, but also we look into elements to compile information and to start financial investigation of the property that person owns. And that is how we managed to score important results. So it is very important to have investigation of this kind. And what we found that we have classical criminal investigation, the classical police investigation, but also side by side financial one to complete and to supply necessary elements for indictment and charges. Financial prosecution and financial investigation is important in order to seize disproportionate property, to seize and confiscate the proceeds of crime with certain economic and owing to the financial and economic expertise and knowledge of people who work with us. As to enable first seizure and then final confiscation of those proceeds. It is very important and it was very important in our context that we fought money laundering, and money laundering is about how to start investigations hand in hand, meaning classical prosecutorial together with financial investigation. So this awareness that investigations are not only about arresting offenders, they are to also aimed equally at seizing their illegal assets. And then it is a bigger shot to enable judges to build a case, so to say, for charges, for convictions and seizure. So there are also third parties who actually assisted by offering financial or commercial services, and who nominally don't go by those obvious criminal elements are not at first look like don't look like criminals, but their role is very delicate, and we need a delicate operation to go after them. So this is a very important activity, and we acquired each competencies. We started better to better understand. We better understood then and afterwards how it's handled, and we better understood all the intricacies of the crime committed. I would stop here, but you will have some other speakers after me, prominent speakers who will be able to explain to me how they went about that in their jurisdictions. I believe we are limited with time anyway. I believe I've explained my point, and I want to thank you for inviting me. I didn't manage to explain all, but however, I hope I managed to present my views. I'm ready to submit my intervention in paper if you wish, and I want to say that I'm also ready there to explain the issue in greater detail in technical terms as well, which is not possible here and in such a short time. I want to thank you once again.
Thank you, Mr. Gaudi, for this exhaustive presentation. Now we'll have here the German experience, Dr. Van Rupert, head of the section for the Southeastern Europe German Foundation for International Legal Cooperation. You have the floor.
Thank you very much. Hopefully I'm visible and hearable now. Dobar dan, ja ću biti veoma kratko, jer znam da smo
I'll be
već
brief because we
prekoračili vreme. Meni je
spent
drago
already too much time. I am
slušam
pleased, and I'm hearing the English translation. I'm pleased that I can speak on behalf of the Foundation for International Legal Cooperation, which works or functions within the German Federal Republic and with the funds of the German Ministry of Foreign Affairs. And I will present Dr. Kreyer, who is the High Prosecutor, but he's also a prominent author of a book on confiscation of assets. He was also an expert in international projects, FARE, Romania, Taiwan, and a guest professor at the University of Köln. So he has practical and theoretical experience, and he will now present the German experience. And he will tell us directly something about the topic. Dr. Kreyer, you have the floor.
Oh, thank you very much. Thank you for having me. I hope that you can hear me and see me. First of all, I would like to start thanking for the invitation. I have to say I'm really impressed by the discussion that we have heard this morning and just from the Italian colleague a couple of minutes ago. Really impressive how profound your discussions are already. And I think you're on a good way to find some legal solutions to your problems. What I would like to point out is basically three issues, which would be what are the basic principles governing the German legal system, our law in this area of confiscation. I would like to point out something about the evolution. It's not a revolution, it's rather evolution in the German legal system over the last years. And I would like to end with, I would like to call it lessons learned. So maybe you can, we can prevent that you make the same mistake that we have made over the years. To start with, the German law has some basic principles like any other legal system. And one, of course, is that the confiscation is a basic pillar. It's nothing new. We've had confiscation regulations in the Roman law in medieval times, and crime shouldn't pay. It's such an obvious formula that anyone should know it who has ever had involvement in criminal investigations. But the question is always, how do you transfer this into national law? As it varies from nation to nation, I would just like to point out some issues concerning the German law. First of all, it's a constitutional question, of course. Property, the right to property is always involved here when we talk about confiscation. And on the German law, the German Constitutional Court held it numerous times that the aim of confiscation is not to sentence. So unlike imprisonment, or if you have to pay a fine as a sentence, the confiscation is rather considered as a way, as a means to revoke a previous illegal shift of assets. Simple example, you have a thief, takes €1,000 from a victim. That obviously is a crime, and it's at the same time, of course, it shifts assets, €1,000 from the victim to the thief. And confiscation should be there to reverse this shift and not to sentence somebody, which means that certain legal regulations that are applicable to a sentence are not applicable to confiscation. We still have the rule of proportionality, of course, but it does not exist in the same way. If you gain a proceed of €1 million from a criminal act, but you don't have it at the end of the day, that doesn't matter. It's your personal problem, and it's a problem of execution. But it's not that you have to say, well, the sentence has to fit the crime. The sentence doesn't have to fit the amount that will be confiscated. And this has a direct impact on the options for confiscation. We can only confiscate the amount that was originally gained through the criminal act or for the criminal act. That's easy in the example with the thief, but it gets more complicated if you have, for example, a bribery case. Someone bribes an official to make sure that a contract will be awarded to a company held by a friend in Malta with the company shares held in the Isle of Guernsey or Man or whatever. next question is, how are you allowed to deduct a certain amount of money? You have to pay for the Maltese company. You have to pay for a road that was subject to the bribe-connected contract. Can you deduct this if it's just reversing a shift of assets? These issues are, under German law, quite ambitious to solve. We have these as issues. We have numerous decisions by the courts, but not really a clear solution. But it's based on the pillar that it is just a reverse of a shift of assets. Another important issue is victims' rights. The victims' rights are always important in these contexts because we are, as we have just pointed out, obliged to reverse the shift of asset back to the victim. You do have a problem if the victim does not cooperate or doesn't want to have his money back for some reason or another, or you don't have a victim. In drug-related cases, you don't have a victim. Still, you can confiscate the money, of course. But as soon as there is a victim, it gets more complicated because another basic principle is that if you want to reverse a shift of asset, you can do it only once. We cannot take the money away from the thief, 1,000 euro, if he had already paid the money back to the victim, because that would be somewhat a double claim against the defendant, and that is not allowed under German law because of, as I just pointed out, we just have to reverse the shift of assets. And that brings us to other problems. We have to ask the question, what if the victim and the criminal, they reach an agreement for some reason or another, sometimes an enforced agreement, sometimes an agreement that actually is out of free will, and the victim settles for 500 euros. So if the victim is compensated and he says, I'm fine with 500 euros because the criminal doesn't have any more, does the crime pay? Are we allowed to get hold of the rest 500 because we wouldn't be making him pay twice? Depending on the legal situations, you have this or this answer. Currently under German law, that would be it. You can keep the rest of the 500 euros if you're a little smart as a criminal. Another principle that I just shortly like to point out is the principle of legality. That's what we call it in the German law, meaning we cannot select the cases that we prosecute. If there is a case, if we have enough evidence to open up an investigation, then this is our legal obligation as prosecutors to do it, and we do it. So it's not that we can select the cases and start an investigation here and skip an investigation on the other hand. If the case does have sufficient evidence, we will have to open it and, of course, have to look at all the financial aspects of a case. And it is very important to always keep in mind that we do not have the option of, I think Dutch law has it here or there, that we can maybe skip one area or another.
Gospodine Greer, kakav je uticaj...
Mr. Greer, what is the influence of the European legislation or the decision of the European Court on the German legal system and your solutions?
Yeah, that's quite a big issue because we pointed this out this morning in the first panel that you've had, that the European regulations, meaning EU or European Council, have quite an impact. On the European level, just as on the international level, there is almost the protection of property. We have it in the German Constitution, Article 14. We have it Article 17, I guess, in the basic rights charter of the European Union. And we have it in the European Convention for Human Rights as well. And we, of course, have to monitor the jurisdiction that comes from the ECHR. The UCOS case was one that was quite important to preliminary measures in this area. And we have to see that the European Union, just as the European Council, both are very active in the area of victim rights. There's a tendency in the last decade probably that the rights of victims were always put more in the focus. And another issue that's quite important in both areas, EU and DC, is anti-money laundering. And we should never, it was, I guess, what my Italian colleague before said, we should never forget the importance of a proper anti-money laundering system in fighting corruption, fighting financial crimes, and in confiscating assets, because the sources to gain knowledge about financial transaction are various, but all those reports by those who are obliged to report under the anti-money laundering regulations on the European level are very valuable. So it's important, yes.
Još jedno pitanje, dakle,
Another question,
Yeah.
from on your own experience, how important it is to establish special teams, because we are in the transitional period where it is necessary to have the distribution of justice properly after 30 years of lack of any judicial epilogues. And we need to concentrate on some specific cases or on the people who have high profiles and who are very important in the society, in the country, and who maybe, but who potentially participated in these kinds of activities.
We have tried to concentrate certain cases, high-profile cases with large damages, for example, with huge assets to be recovered, in a certain special unit. But to be quite honest, it didn't work. We have, as you know, a federal system in Germany. We have 16 states making up the Federal Republic of Germany. North Rhine-Westphalia, the home state that I come from, is not the biggest. Bavaria is a little bigger, but the most populous state is North Rhine-Westphalia. So we have quite the resources actually to try this concentration. We did it, but maybe this always is an aspect of lessons learned, but we've tried to make it more an advisory body. You could call the colleagues there, they were highly qualified, they knew all the tricks. You could call them if you had a difficult case and ask them for advice, but they did not actually take the cases. They could have, but it wasn't wanted, there was not the political will maybe to concentrate the cases there. So we keep the cases with the local public prosecutor's office. In Cologne, we have a little more than 200 prosecutors, so we have the option to specialize. We have specialized colleagues. I was one of those specializing in question of confiscation. We have the option to do this, but of course I see that just like the smaller states in Germany, maybe Montenegro does not have these options. So to start with and to get it going, I think it is important to get some expert together, and if the legal system in Montenegro offers this opportunity, to maybe assign those cases to a group specialized in this area. And that should be, of course, people knowing the tax regulations, because it's always important to take a look at the tax files to know which tax details you might include in a criminal investigation, which you might not. Police officers, forensic experts, and cyber. We have a special cyber unit here. They often help us talk about cryptocurrency. This is an issue that is getting more and more important. And of course, prosecutors under German law, the prosecutor is in charge of the investigation, the preliminary investigation. So to bring them all together would be the best way. We are not doing this. Maybe this is an explanation why we're not that successful in some cases. But I think that it's also important for a long-term strategy to get everybody, each and every prosecutor, each and every police officer in the country to know the rules, the plain vanilla cases, the simple cases. If you work on these cases and they actually work, you succeed, then you get experience and then you get the trust to go on the bigger cases. And that is always difficult to do just by training. So experience is important. If you have some experience, it's easier to go for the high-profile cases. I hope this answers your question.
Hvala vam na učešću I hvala vam na...
Thank you for your participation and your presentation of your precious experience and suggestion. And now it's the time to refer to Mr. Rupert Winning from the UK. He's expert in the rule of law and fights against organized crime and corruption. Hello, Mr. Winning. We hope you can hear us.
I can hear you. Hopefully you can hear me.
Čujemo vas odlično.
Can you hear me?
Odlično. Čujemo vas. Izvolite.
Can you hear me?
Čujem, odlično.
Yes, we can hear you. I can hear you. Everything's okay. Is everything okay with you?
Are you able to hear me?
Yes, yes, we can hear you.
Well, I appear not to be having any interaction. Up your messages on chat, and I will take it from there if there's difficulty, and doubtless Mariana will assist. Firstly, thank you for inviting me to speak today on partly the UK experience concerning confiscation and the proceeds of crime. I am, in fact, a UK Crown advocate, but I should point out to you that what I say today is not on behalf of the Crown Prosecution Service, but simply my experience working within the region of Southeast Europe, and in particular in Montenegro, and applying the legal knowledge and experience I have. I listened with interest to Dr. Greyer's description of the position in Germany. I think that the UK regime is slightly more aggressive than the German regime. He may correct me on points of detail. Our system uses the same theory that the German system appears to use. That is that confiscation is not a punishment. It is reimbursement of what should not have belonged to the suspect in the first place, and is obtained via their offending or as a benefit via their offending. And here I think the difference may be a little more plain. In the UK, it is possible to have an extended regime of confiscation that goes beyond the mere conduct of the offence itself and is termed as a lifestyle offence. If you are convicted of a specified category of offences, which could include bribery, could include possession with intent to supply drugs, you are made liable to extended confiscation, the so-called lifestyle offences. In that case, the state makes the presumption that all assets in a previous period of years that you have in your possession is the product of your criminality. And it is for you as the suspect to disprove that you acquired that material through criminality. This, in large part, I would describe as in rem confiscation. Using Dr. Greyer's list, victims' rights, yes, confiscation can be diverted to a victim if need be. And yes, we are careful to avoid double claims. No, we do not apply the legality principle in the UK. We operate under a prosecutorial code test, which requires a test of sufficiency of evidence and of it being in the public interest. For the purposes of this quick discussion, in the public interest means that it is right to prosecute. Therefore, we are not obliged to prosecute in the same way that Mr. Dr. Greyer or his colleagues would be required to do. Dr. Greyer raises the impact of the judgment. I had the privilege to advise in Montenegro the then Deputy Prime Minister on the notion of unexplained wealth and illicit enrichment. And I was able to show in the paper I produced, which I think Mans has a copy of, that UK legislation, which, although aggressive, has been adjudged to be compliant with the European Court of Human Rights and the European Convention on Human Rights. And indeed, that included, for example, the reverse burden of proof, which is integral to the offence of unexplained wealth. I am interested in Dr. Greyer's point about capacity in Montenegro to deal with notions of confiscation and unexplained wealth. It is a highly specialized subject, and whilst the UK does have powerful legislation, the success rate with our Proceeds of Crime Act and indeed with the Unexplained Wealth Order that came into effect in 2017 has been particularly difficult around the issues of third-party ownership of assets, and that becomes even more difficult where you're dealing with the Unexplained Wealth Order. In my view, Montenegro should not necessarily take off-the-shelf legislation that is used in Western Europe. Our resources are greater than Montenegro's, for instance, in the UK, doubtless in the Federal Republic of Germany. What Montenegro needs is something that is practical and usable by ordinary prosecutors. By all means, have a specialized unit for reference and expertise, but above all, make any legislation that is introduced into Montenegro user-friendly for prosecutors and financial analysts. Financial analysis is a very difficult, challenging subject, and the higher value the potential claim, the greater resistance you are likely to get from highly skilled lawyers who argue that the defendant's possession or the defendant's family's possession of assets is genuine and should not be challenged. So, although I am not asked to do it in this segment, I have been asked to advise Montenegro at high level previously, and indeed offer government level advice across the region. My emphatic advice is by all means build expertise, possibly concentrate expertise in an advisory capacity, but do not make a direct import of legislation which implies all the resources that the United Kingdom or, for example, the Federal Republic of Germany would have, or indeed the Republic of Italy. It simply is beyond Montenegro's capacity, in my view, to use. As I say, I did offer government level advice to, he was then, I think, Deputy Prime Minister Markovic, and in the end that legislation was not progressed with. I understand my colleagues from the UK are proposing a different form of confiscation, and I wish them success with that, and if time permits today, I will listen to their presentation later. At this point, I would invite any questions anyone has in relation to what I've talked about.
Je li ima nekih konkretnih pitanja? Dobro, predlažem, zahvaljujem se gospodinu Viningu.
Thank you, Mr. Winning. Now we will proceed with Claudio Valentini, Unit for Preventive Investigations from Unit for Fighting Mafia from Italy.
Dobar dan, gospodine Valentini. Izvolite.
Buongiorno, mi sentite?
Dobar dan, čujemo se, izvolite.
Ok, dobar dan svime. Io sono il tenente, il colonnello Roberto Dieghi.
Hi. Hi. She from the Preventive Investigation Unit from Anti-Mafia Investigative Directorate has cooperated with you. We've been using this model for quite a while. I come from the Office of Foreign Affairs, which also has internal affairs, which also has this department, financial police and classical police. So we have the task to fight mafia in Italy. As my our friend, Mr. Prosecutor Gaudi mentioned, our mafia organizations developed in such a way that all that we had to develop, that in Italy we had to develop the system in such a way that we have parallel investigations. So now we even have preventive investigations, which are very important in fight against mafia. So they are very effective, even more effective than judicial investigations. We want to hit them hard and hit them on property. This was proven to be the most efficient form of fight against mafia. Preventive activity is based on a couple of aspects. Preventive measures that I will reflect upon today. Fight against money laundering through analysis of suspicious financial operations. Again, a very important instrument. And prevention and fight of against infiltration of mafia organizations into big public tenders. So funded mostly by the EU money. So this is a very interesting trade for mafia organizations. So today we have silent mafia, which was mentioned by prosecutor. Mafia is not so visible any longer with killings and violence in the streets. What they try to do is to recycle or launder and legalize illegally acquired property, proceeds of crime, mostly coming from the smuggling of drugs, not only from there. We use preventive measures because we want to preempt those cases. And that is why I'll give the floor to my colleague, Claudia Valentino, who comes from the financial police. And who is a member of this team who works on preventive investigation in our directorate, anti-mafia directorate. Hi, everyone. Within as a part of preventive activities, I make assessments on indirect and direct suspicions, presumptions about measures that operational centers or Guardia di Finanza could do. We have our outposts throughout Italy. So they give us information in order to do the preventive investigation. So it was short. Targeting property has always been very important when it comes to the investigations and prosecutions and policing work. So the militant power of mafia organizations and their power in the field is a part of the universe of mafia work. What worries us is the capacity of mafia organizations to penetrate into the economic tissue in our country. And these, in this, the tenders are most vulnerable in this regard, I mean. So through that, they managed to accumulate lots of funds, what mafia is about is to legalize illegal money, to spin it over into ostensibly legal economic activity. What is important first is to have legislative framework. Concretely speaking, we have to have the measures in place that will enable to make assessment of illegal property and then connect it, trace it back to where it came from. So our goal was to target the criminal organizations and their capacity of controlling the territory, and that we do that in preventive measures of personal character, and you'll see later which these are. These are the measures that limit the personal freedom of a subject when it comes to financial aspects of mafia work. They have some power, they command power, and it's very important to take the property proceeds from them whenever we anytime we prove that it comes from illegal sources. Legislation regarding preventive measures is a part of norms related to fight against organized crime. It is about, and it is a legal procedure, it is a judicial procedure that works on anticipatory basis. So you don't need to establish the existence of offense or the facts of it, and we can start an activity based on indications only. So what are characteristics of and procedures that we use in prevention compared to criminal proceedings? So there are two autonomous procedures when it comes to how it works. Preventive investigations are focused on examining or establishing social danger that an entity presents for the society, I mean, whereas criminal one has to prove criminal offense and criminal accountability of a subject. Between these two proceedings, as Prosecutor Gaudio said, we have this twin track approach. We have the law, anti-mafia law, that enables the autonomy. It gives and bestows autonomy on both of these, so each can run autonomously, so criminal and proceedings related to preventive or asset seizure part. So we have criminal proceedings aiming at establishing the criminal offense and repression, and it can lead to criminal seizure, so that we could take away, that we could seize property that has been acquired through that criminal offense, while preventive one aims at establishing a social threat that such a subject becomes, and we can determine that even in the absence of criminal offense, and what then confirmed through establishing or proving the criminal offense. preventive proceedings, that if we compare it to criminal offense in classical terms, has judicial character, which is to say that these procedures are applied and used by, run by judicial authorities. It has procedural characteristics that are similar to criminal proceedings, where you have the right to defend yourself, to adversary proceedings, you hear also all parties involved. However, when it comes to its final outcome, it is the process, through this process, that we could, for example, take away documents, seize the documents and papers, and other things that that are issued or given to those people who they possess, which they possess. So, when given all the norms that apply to this, we envisage that the entities such as police and prosecutors could suggest that. So we have the director of Anti-Mafia Directorate can and has the mandate such the same as minister, the director of police have equivalent competencies, and they can order the procedure to start. The same is that the prosecutors and judiciary can ask that, legislator wanted to distinguish between different social threats, threats to society. If it is qualified social threat, then it is the judiciary body that is in charge of ordering this proceeding. So those could be anti-mafia prosecutors, and if they establish then the social threat of regional standing, then we have the district prosecutors getting involved. So we can run locally, regionally, and at national level. What are the presumptions for application of preventive measures? We mentioned this social threat, that this subject, that this person is. So in preventive measures, you don't need to have this social threat or social jeopardy proved. So it is very important that this measure is ordered at the moment when the property is there and at disposal, and we could start our preventive investigation. The value of the property that we are to confiscate has to be such as to be disproportionate to the material and economic capacities that that person or that subject commands. So we have to prove that this property is a result of some illegal activity then. There are alternatives. So we have to have those So we should find two things, either disproportion or indications that certain property was acquired through criminal activity. Depending on how dangerous are for a society. So these are subjects or entities who are very dangerous in general terms. Also, the anti-mafia law defines a whole series, whole string of criminal offenses that are within the jurisdiction of territorial of the unit, anti-mafia unit covering that territory. It is Article 416 of our criminal code, where we have mafia members, camera members, so then people assisting them, then prostitutes, drug dealers, those who are associated in order to smuggle narcotics and drugs. So these are the serious criminal offenses that fall within the jurisdiction of this department. So we can order preventive property measures, and which is the discipline necessary to apply. So we should start property investigations, and Del Gaudio spoke about that. They are absolutely necessary in order to have the directorate, the anti-mafia directorate or police order. So they are necessary for those to order the process to establish what the property of that person is. So we analyze and examine the lifestyle of a person's subjective and objective profile, both. We look at the lifestyle of that person. We look at the tax filings compared to what he possesses and has at disposal. So whether he owns yachts, or he bets at horse races and so on and so forth. What are the financial means he or she disposes of? We can also analyze the accounts, and we can examine the records of all the property that person has. So disposal of property could be direct or indirect as the law prescribes. So it is not necessary that that person is a formal owner, because in most cases, almost all cases, that is not the beneficial owner. And that is why we check on persons who live in the same home or lived in the same home with that person anytime within last within 5 years time. So we check all of them who have lived with that person in the last 5 years, and if we establish some disproportionate lifestyle compared to the property. So what financial police does when we have the preventive activities of this kind, we look at all elements. We make a kind of snapshot of that person, what he or she engaged into so far, which offenses, activities, and so we use a lot the databases and try to profile a person. And then we try to make sure that we map all the connections that a person has. And then we compare it to against the property they do possess, in order to get an idea based on, in order to establish whether the person took part in, for example, bids as well. We try to look at the evolvement, if you wish, of the acquiring process, how and what he acquired over time. Was it purchased at the moment when that person was considered dangerous for the society? And this is one of the elements that make this social threat or threat to society that we deal with at investigation. So so some indications or presumptions are enough for us to start the proceedings, to connect that with the organized crime organizations and individuals. The second path of investigation is following. We file to the competent court on information, and after that, what we do with the property, it becomes the possession. It gets becomes a property of the state, and it is managed by our national agency for confiscated property. This would be really a snapshot as overview of our system for confiscation. Thank you very much for your cooperation. I want to add just this, that in this presentation we reduced lots or left out lots of things. You can just imagine that this activity, especially activity focused on proving the accumulated property, and the fact that property is a result of the criminal offense, is very complex. And after so many experience, I want to tell you that this preventive investigation and financial investigation is much more difficult than the classical one. So when it comes to this topic, we tried our best to present the stuff. I don't know if we managed. I would like to add that even if, when it comes to Interpol and connections that we have, you can lodge all kinds of requests, formal, informal, question, you can ask for clarification of some aspect, and we are more than happy to do what you request.
Thank you. Now we'll have several minute break, and then we'll continue with the next panel, referring to the civil forfeiture of criminal assets.
l'audio dopo. No.
I'm afraid that we do not have the sound. Let's hope it will get it. Milica! Milica!
Da li se čujemo?
Now we have the sound. Hello, can you hear us?
We can, yes.
Yes, we can.
Great, great. So, to cut the long story short, let's see what are your recommendations regarding the adoption of the new law in Montenegro, based on your personal international experience and your work in the region and in the European Union.
Maybe I shall start then.
Slažem se.
First of all,
Možda je tako najbolje.
thank you very much.
That's the best thing.
Yes. Thank you very much for the invitation this afternoon to discuss a topic that has been of interest to me for probably the last 20 years. My name is Jill Thomas, and I am currently an asset recovery technical assistance advisor, supporting the development of all aspects of confiscating criminal proceeds across various regions of the world. Currently, I'm working in West and Central Asia, the Middle East and North Africa, and I have some extensive work in the Balkans. My background is in law enforcement. I have over 30 years experience as a criminal and financial investigator. However, the reason I've been asked to participate in this panel is that for the last 11 years of my law enforcement career, I managed the Europol Criminal Asset Bureau, so the European Asset Recovery Office, if you like. Supporting investigation teams in Europe to trace and identify assets located outside of their national boundaries for cases involving a serious and international crime. During this time, I also managed the Secretariat of the Asset Recovery Network, the international network of practitioners, called CARIN, and actually currently I manage the Balkan International Asset Management Network called BAMIN, to which Montenegro is also a member, in fact a member of both of those groups. And I think I will talk about international cooperation for civil forfeiture in a moment. There's been some mention today already about the relevance of Europe in this topic, and specifically the relevance of the EU Commission. And I coordinated the activities of the asset recovery offices in Europe and the important work within the European Union on the development of asset recovery law and policy, including the issue of civil forfeiture. And finally, I was very fortunate to be involved in a research topic as part of my own private academic work, my master's degree in international criminal justice, with a thesis that studied the introduction and implementation of non-conviction based confiscation in the European Union. This was in the late 2007, 2010, when this topic was really in the primary stage of discussion in the European Union, and there was some extremely interesting revelations that came out of that study. But I will focus more this afternoon on the international view of civil forfeiture. And one of the things I was asked to explain was that, in my opinion, what changes should Montenegro make in terms of legislation based on the international landscape, both in the European Union, also in the Balkans, but also across the world. And I think in order to do that, it's important to explain that there have been 4 types of non-conviction based confiscation elaborated by the practitioners in this field. I will just briefly explain these 4 models, but the reason why the practitioners came up with these 4 models is that I heard this morning that the Minister for Justice said that this was a revolutionary approach of civil forfeiture, and certainly for Montenegro it is revolutionary, but fortunately for Montenegro it is not revolutionary necessarily for the rest of the world. And practitioners have been talking about this topic, developing their legislation since the early 2000s. And as a result of that, there were some difficulties that emerged in international cooperation. Because as our previous speaker before the break indicated, it's very important for jurisdictions to adopt legislation that suits their own legislation and institutional structures and their own constitution. Extremely important not to just take an off-the-shelf type of legislation. But as a result of that, and as a result of the various types of non-conviction based legislation that have been adopted, international cooperation became extremely difficult. So in order to help that, the practitioners involved in international cooperation came up with 4 models so that they could support each other when one jurisdiction made a request for its confiscation order to be enforced in another jurisdiction, and that confiscation order was based on a civil forfeiture type of legislation. And this is one of the challenges that Montenegro will come to face. And those 4 types of non-conviction based confiscation are as follows. First of all, there is the confiscation of property during a criminal prosecution when the prosecution itself cannot be concluded for one reason or another. And Montenegro has this in its legislative toolbox already, in the case of death of the defendant, or when the instituted proceedings cannot be continued due to the existence of some circumstances which preclude the prosecution. And this is the most common type of non-conviction based confiscation. Most jurisdictions will have this in their criminal codes. The second, and we've heard about this as well today, because Montenegro, together with all the other jurisdictions in the Balkan region, have this extended confiscation, or also referred to as enhanced confiscation, which is where assets are confiscated and these assets are not connected to the offence for which the defendant is before the court. And under a number of different circumstances, it may be that the court makes certain assumptions, or it may be that the confiscation is based on a disproportionate amount of funds between legal income and assets owned. And Montenegro has this, and we heard from the President of the High Court this morning that yes, it does have it, but it has experienced considerable difficulties in implementing extended confiscation, and there may be several reasons for that. The third model is in fact the civil forfeiture in rem action against the property, not the person, which we've heard about today. And this is more the classic civil forfeiture that jurisdictions tend to talk about. And then the fourth model is the unexplained wealth model. And this is an approach whereby it's also an action against the property, not the person, but that there is a disproportionate value between the assets that are owned and the legal income that is being earned by an individual, and the confiscation is based on that disproportionality. Now, those four models may happen in the criminal process or the civil process. So, for example, model type 1 and extended confiscation type 2 generally happen in a criminal procedure, whereas the civil forfeiture type 3 is a civil approach, and type 4 is generally civil, but there are jurisdictions, particularly in Latin America, that have criminalized their unexplained wealth provisions. And in fact, France has also made it a criminal offence to own unexplained wealth. Now, these are not absolute, clearly defined types. Jurisdictions have adopted maybe one or two of them, or maybe their extended confiscation may have some aspects of civil proceedings within it, such as within the UK, and we'll hear a bit more about that in a moment. But what I would encourage Montenegro to do is to continue to develop its laws in a direction that allows for as many different types of confiscation as possible. There are many jurisdictions that have all four models of non-conviction based confiscation, in addition to their classic conviction based laws for confiscation. Montenegro currently has the first two, the confiscation of property when the prosecution cannot be concluded, and, as we've heard, the extended confiscation. It's now considering further provisions that include civil forfeiture, and I would encourage the continued development of those. I think probably my colleague Tristan Hicks will add another type of confiscation to those four in a moment. But just to finish off in relation to the models, I would also remind our Montenegrin colleagues that this does not happen overnight. The UK's Proceeds of Crime Act has existed for 20 years now and is still continuing to develop, and recently has introduced certain new provisions that have made it even more effective. And sometimes the provisions that are introduced are not as successful and they need a little more work. And perhaps that is the case for Montenegro's extended confiscation legislation, even if that work is in the area of implementation rather than amendments to the law. So one other area before I pass over to my colleagues, I don't want to take all the time, one other area I was asked to just mention was what tools are available to Montenegro in relation to international cooperation when it has finally adopted its civil forfeiture laws. And I would split this question into two. When you are seeking to confiscate assets, the first thing you have to do is find them. If you don't find any assets, then you will find it difficult to confiscate at the end of your case. So financial investigation tends to work very smoothly internationally, as smoothly as criminal confiscation financial investigation does. There are certain international networks to which Montenegro are a member that will provide them a platform, a legal platform, and a secure platform to exchange information for financial investigation for civil forfeiture. And the Montenegro police have a contact in the CARIN network, as does the Special Prosecutor's Office, also have a contact in the same network. The more difficult area, as I have already alluded to, is in terms of the recognition of orders to enforce for sequestration and confiscation when those orders have been made based on civil proceedings. Some jurisdictions have difficulty in recognizing these orders when they themselves do not have a legal system that allows for civil forfeiture or civil unexplained wealth. However, what I would say to our colleagues, our prosecutors in Montenegro, is please, all is not lost. There are a number of international cases that have been successful. There's a very famous case called the Crisafulli case, which involved the courts in France recognizing and executing a foreign non-conviction based confiscation order from Italy, that even though France does not have that type of legal regime. Countries are, by international standards, encouraged to look beyond the terminology that's used by requesting jurisdictions and examine if the cooperation that has been sought meets the legal requirements of its own domestic legal system, and to respond. And perhaps a final thing I will say in terms of international cooperation is that although the European Union are looking very closely into an instrument, a regional instrument for civil forfeiture. There is not one yet. The international standards that exist encourage jurisdictions to enforce orders based on non-conviction based civil forfeiture requests. So there is clearly an indication there that this is a developing and a growing type of legal mechanism, and that countries are encouraged to recognise and respond to orders and requests when they're made. I think I'm going to leave it there and maybe pass over to back to our moderator for the next panel member.
Thank you, Ms. Thomas. Now we'll hear Tris Hicks, the expert for the recovery of assets gained through or acquired through organized crime. Can you hear us?
I can, Peter. Nice to see you.
Dobar dan. Hvala što ste se nama. Počet ću ovim pitanjem. Kako mislite...
Being with us, I'll start with a question. What should be the priorities or priority cases? What would you suggest in this regard? So what are the lessons learned through evolution of these laws and legislation, judging from your experience, international experience, I mean?
Okay. Thank you for the question. Thank you, Jill. Good afternoon, everybody. I'll give a quick introduction of myself, and then I will answer the question, and then I'll hand over to Barbara. My background is as a police officer. I was a police colonel rank. I was in charge of all of the police financial investigators in London. The evolution of the law in the UK was revolutionised in 2003 by a new law. And the evolution before that is a story of legal and practical failure. And when the new law came in, it became a story of success. And I happened to be in charge of the financial investigators, the very few financial investigators in London when that happened. I should explain that the police in the UK have a different role from Europe. A police officer like me, I would decide what would be investigated, who would be investigated. I would authorise special techniques. If I needed a prosecutor's help to freeze assets, then I would contact a prosecutor. But essentially, everything belongs to the police. We do the investigation, we hand over to the prosecutor to present the case in court, according to the criteria that Rupert told us about an hour ago. So the police role is quite different. When the law changed in 2003, the UK formed a National Implementation Committee for the new law. And because of my role, I became a member of that committee, which then carried on for the next 10 years as the law evolved and as we solved the practical problems that were presented to us by implementing a new law using a system which had a history of failure. So I'm going to talk about the evolution a little. So the previous law started in 1986, and there were a number of changes for the next 15 years which more or less failed to deliver the tools needed to make the law work in a practical way. And the law of 2003, the Proceeds of Crime Act, was a comprehensive revision, a revolutionary revision, which provided, as Jill put it, all four methods of asset recovery, of non-conviction based confiscation. All of those were available all of a sudden. And there was a fifth power specific to England and Wales, but it also exists in Ireland and has done for many years in the United States, which is the in rem possibility to confiscate cash, by which I mean folding paper money. A specific power to litigate cash which has been found by the police on the balance of probabilities. And this was the key power that moved us from failure to success. Now, the reason for that is because the cash confiscation power provides quick seizure of cash, quick litigation by the police, so not by the prosecutor, but by the police, on the balance of probabilities in the criminal court. And the reality of that is you get very quick results. And that changed everything in the UK. We started with poor law that did not work. We started with low capacity. I was in charge of only 25 financial investigators in a city of 10 million people. That's all we had. And the cash allowed us to test easy cases against ordinary criminals in the courts, so that when they were appealed and when they were linked to crime, as they often were, then prosecutors would get experience of dealing with easy cases of asset recovery at a practical level, which is what Rupert was saying earlier. His recommendation was that the powers should be used by ordinary prosecutors in ordinary cases. And I strongly agree with that. And it was the cash seizure power that allowed us to do that quickly and get quick results. Furthermore, the cash, or most of the cash, was ploughed back into the police and prosecuting agencies. So we solved the capacity problem of very few investigators by buying more using the cash. And although, yes, it is a specialist area in confiscation, we found that we could take good, experienced detectives and train them in financial investigation, and that produced excellent results quickly. So that's the main thing I wanted to say. My recommendation for the new law is that Montenegro should consider having a law that offers all four systems, all four models that Jill identified, plus the cash seizure model as well. Because this has a history of success. We know that it works for decades in a number of different jurisdictions. And I should just add that the United Kingdom is actually a number of different legal jurisdictions from a criminal law perspective. And the different models that Jill outlined had different successes in the different parts of the kingdom. So in Southern Ireland, which is an independent country, the tax measures were the most effective tool against organised crime. In the north of Ireland, the in rem confiscation against assets was the most successful thing. In England, the most successful power was cash seizure, and cash confiscation still makes up between a quarter and a third of all of the assets that were recovered in the United Kingdom. So different environments, different societies produce different results, which is why I recommend that Montenegro considers having all the options. Why not have the whole toolbox? And then you can choose what works and see whether it does. So that's my strong recommendation. And finally, to give an idea of the difference between failure and success, under the old law in the UK, all of the agencies in the United Kingdom recovered about 15 million euros per year. So throughout the 1990s, only 15 million euros was recovered from what is a very big and a well-provisioned country. After the new law, the amount recovered doubled every 18 months to reach a total of 200 million euros every year. And that's still the case now. Now, personally, I think we could do better. But that was the change that I want to emphasize. We went from 15 million to 200 million. The reason that happened was because of the cash seizure power, the choices available to litigate assets, and the fact that we had an implementation committee to work through the problems as they were discovered. So we mapped out the legal system, and as we discovered things didn't work in the chain because no one used a lot of the administrative powers, we didn't use them in many of the agencies, that implementation committee fixed the problems as we went along. And it was a critical success ingredient. That's enough from me. I know Peter's got some more questions for us, and I hope that this will become more of a dialogue and more of a discussion, less of a monologue from me. But thank you so far.
Hvala najljepše. Na vezi imamo I Barbaru
Thank you so much. We have Barbara Lipovšek, special prosecutor from Slovenia.
Dobar dan.
Good afternoon. We're pleased to hear you. I hope you can hear me so I can start. We have a few questions before you start. I will just perhaps give you some guidelines and then you can proceed. We heard in the introductory panels some skepticism of some people regarding challenges and this also protection of human rights, because we are here making pioneering steps after 30 years and we have to rely on weak potentials in the prosecutor's office. So what are your suggestions regarding legislation and what we should do, and what are your experiences? Thank you for your questions. Everything that you have just mentioned is something that I was going to say about, but I'm Barbara Lipovšek. I come from Slovenia. I'm a specialized state prosecutor at the Specialized State Prosecutor's Office in Ljubljana in Slovenia. Regarding forfeiture of assets, I have worked for a long time, actually since the beginning of my career within the Special Prosecutor's Office. That's since 2012. Before that, I was a district prosecutor in the District Prosecutor's Office in Celje, the town in Slovenia. And before that, I worked in the state, in the Ombudsman. And before that, I worked in a multinational company. So I have experience in this, with this very important field. And all these things have helped me in the job I'm doing now. In Slovenia, there is a special law. We don't have the Institute of Forfeiture of Criminal Assets is not a part of the criminal code. It's a special law. That law was adopted in 2011. So in practice, we started working on it at the beginning of 2012. And we have crossed this path that's been very specific, because it was the first time in history that prosecutors were forced to work on the segment of civil law on the highest level. It's normal that in prosecutor's office we'll deal with different procedures, but this was a sort of a mixed up system that was not clear to us at the beginning. But when I look backwards, I think that the way things function in Slovenia were already defined well at the beginning. And I will describe the main problems and how we overcame them. And before I explain that, I just want to say that in Slovenia, we use the so-called cascade approach. We take into consideration the assets acquired through criminal proceedings. We have this extended confiscation, but a little bit more limited than in Montenegro. And then the third one is in a REM procedure, which is defined by a special law. And the fourth possibility that we have in mind is that we see that these in REM procedures don't seem successful. We resort to the tax approach procedure. I don't know how to explain it, but when the tax administration collects taxes and there is a situation that somebody has more assets that they could really earn, then but it still doesn't have anything to do with the criminal procedure. What is the characteristic of our procedure, which which entered into force in 2011, but we started working on it in 2012, and it was already amended in 2014. Perhaps in the introduction, you can tell us, because we heard in the previous panels that one draft of the law was not accepted by the Constitutional Court. So what was the reason for that? Perhaps we can still find some time to avoid some problems that you had in your initial stage. I understand what you mean. What you should pay attention to is the difficulties that we had in Slovenia as well. This law, in its first draft, when it entered into force, actually, it had a provision that we can do financial investigations from the 1st of January 1990. So that was the provision that was the Constitutional Court said that it was a retroactive approach and it had to cease to be valid. And in 2018, we had to actually terminate 11 or 12 proceedings that were already before the court. So we had to terminate all those proceedings, and also we had to pay all the costs that the parties had before the court. So I think that it is very important for every law, and we have learned a lesson from that, is that the law must clear time of entry into force. So when these things, the investigations can start, because already in 2012, lawyers said that that provision was unconstitutional, we got the constitutional decision 10 years later, which is a long period. And if you have these limits clear at the very beginning, then you can have more successful examples. But by all means, we are satisfied with the development of this institute. Why I mentioned development? Because it's a new area for prosecutors, and every institution should do its best to develop this institute. We still monitor all those problems, shortcomings, everything that can help us to accelerate the investigation procedures, also all the evidence we can present before the court, so that we can have court decisions in favor of the state of Slovenia. What could be also a recommendation? We have 2 or 3 constitutional decisions. The first one was this retroactive approach, which drastically influenced our proceedings. There was a decision from 2017, I think, which showed what could be confiscated in the civil procedure. The procedure is divided into 2 stages. The first one is the financial investigation, which is limited to a year and a half. So if the financial investigation yields results, if there is illegal source of assets in the civil proceedings before the court, we ask the entity, the person, we actually confiscate the person's assets. But another decision of the Constitutional Court said that we cannot confiscate anything else except what the person gained during the financial investigation. And in financial investigation can cover the period of not more than 5 years from the moment from the time when somebody committed a criminal offense until now. So if the first decision of the Constitutional Court said that we cannot start anymore from the 1st of January 1990, but on the 29th of November 2011, that's when the law entered into force, then the second decision of the Constitutional Court said that we can go back regarding financial investigation 5 years before the decision until now. So in the financial investigation, we calculate a lot the discrepancy between the assets the person had and the income of that person. But that calculation includes the assets which the person had at one point but doesn't have it anymore. So you can see that the person sold the house and then bought a house and then sold it. Then they actually bought cocaine and they sniffed it. So it doesn't exist anymore. So because the assets do not exist anymore, but in order, in such situations, we can take other assets that the person gained before, but is not within the period of the financial investigation. So we tried several times in the court and we failed, because when we did calculate, but we didn't have the assets to confiscate. So we formulated our approach in such a way that they had to pay for that property, for the assets, because if they don't pay, we have the legal power of 10 years and we can, based on that, confiscate the assets, even the assets that the person had got at the stage when, let's say, the person's mother died and he inherited that property. So that's the process we tried, so that the person cannot have the legal assets, but if you don't find those assets that he gained through criminal activities, that he can gain, confiscate some other assets to compensate for the illegal assets. Now we think that it's a fair approach, but we still wait for the authorities to decide whether it's constitutional or not. Now I could mention also some other solutions that seem to be good, and I think we've been quite creative, and this may give a good idea not only to Montenegro but to some other parties. The human rights generally are important. So in the amendments to the law in 2014, we said that the Financial Investigation Group completes its job when they collect information, evidence on income, on assets, and when we calculate the discrepancy, then the person who is under investigation must be informed about the results and give the person the possibility to decide. Although that stage of investigation was a secret, once it's completed, when we already have the possibility to confiscate the assets, and at that point it's not dangerous if the person finds out about the results. So the person is informed about our results and they can give a statement on that. What does this mean? It means that before we start with the civil proceedings, if the person provides or explains how he got that property or has a legal ground for that, that we can check and see that it's a property of legal origin, then we can reduce the amount calculated. But we have never had such a situation so far. No one has ever provided any documents to justify this discrepancy between the assets and the income. We're still waiting for such an example. We haven't had it so far. A second thing is that it was interesting to see, because Slovenia has a population of 2 million and we have around 200 prosecutors. We work in 12 different prosecutors' offices, but the primary thing is prosecution, of course. So we resolved the situation in such a way that the Special State Prosecutor's Office established a unit called Civil Financial Unit. That was in 2014. So in criminal cases, in addition to criminal cases, we work with civil cases. So all the prosecutors throughout Slovenia can decide to carry out financial investigations. And that's the first phase. They establish a financial team. These are compulsory financial teams. Prosecutors never do that on their own because they don't have enough knowledge or information for that. So the financial team includes representatives of the police, financial administration, and if necessary, representatives of the Anti-Corruption Agency and the Agency for Prevention of Money Laundering. sometimes some other institutions, but these 4 institutions are the most important. They have to have their representatives. And the most important ones are those coming from the financial administration, because they applied the methods prescribed by the OECD and are clear and easily understandable. The prosecutors cannot do those calculations on their own. Investigation is a different thing. So all the prosecutors' offices do those investigations, and once they result in identification of this difference between the assets and the income, then it is forwarded to our special prosecutor's office. That is my department that I manage. And during these years, since 2012, we've been trained for this segment, and we have also employed true specialists, to experts for civil cases. So there are 3 or 4 prosecutors who represent the cases before the court, and we have this specialized knowledge, and we put it in this small segment, because otherwise it would be very difficult for all prosecutors to be trained for all these, both these areas, the criminal proceedings and the civil proceedings. And I can say that civil proceedings are very difficult, because people do their best to keep their money, and when we have the court hearings, they hire the best lawyers firms. A lot of these lawyers, there can be several firms representing just one person, so it's a tough fight. And when the situation is clear, and that's actually when we confiscate assets acquired through obvious criminal activities, when there was drug or prostitution, because we have really people who have dealt with these criminal offenses all their life, and they never had any legal income. So it's easy with them. It's much more difficult when you have persons who have worked all their life in high positions. Very often they did have good income, because the priority in our procedure is that we never confiscate something that is the subject of the criminal procedure. So when there is in such situation, we deal with in REM situations with a small part, a small share. This is the property that is known to be acquired through illegal activities, but we could not identify it based on the criminal offense, because if it is based on the criminal offense, then it's located there. So now I want to conclude that we are intensively working on identification of criminal proceedings that would be interesting to start with the financial investigation, then proceeded in REM proceedings. So we also do our best to improve our procedures. We do analytical job, data processing, and we try to see how our law can be amended. Our law has only 58 articles, and I must say that we can easily apply it, and we look forward to all the challenges ahead of us. So if there are any questions, I'm ready to answer them. Thank you. Based on your presentation, we could hear how sensitive this issue is, and we have very limited potentials in that field. Are there any questions for any of the participants of this panel?
Jedan sekund, evo, Vanja traži mikrofon samo.
Vanja ni...
Dobar dan, hvala vam puno na vašem učešću i na tome što ste dijelili vaše iskustva sa nama. Čuli smo i od gospodina Winninga i od gospodina Hicksa preporuku da se počne sa manjim i jednostavnijim slučajima. Ono zbog čega smo mi zabrinuti je da će ostati na manjim i jednostavnijim slučajima. Da li se tako nešto desilo u Sloveniji? Na koji način ste odlučivali koji su to prioritetni predmeti? Razumijem da ste pokušali da to primijenite od 90. godine, ali da u tome niste uspjeli. Međutim, na koji način odlučujete šta su prioriteti? Da li imate neku granicu preko koje se ta imovina oduzima? U Crnoj Gori, na primjer, se predlaže da ta granica bude 50.000 eura. Razlike između prihoda koji se mogu dokazati i imovine koja je stečena. Nas brine da to možda može da ostavi preveliki prostor za djelovanje tužilaštva u smislu da onda maltene svi građani budu izloženi tome zakonu, što suštinski nije njegova intencija. Pa me interesuje, pogotovo od vas iz Slovenije, jer vi razumijete kontekst u kome mi funkcionišemo na Balkanu. Kako ste vi tome pristupili? Da li ste i vi krenuli od manjih slučajeva i na koji način ste se bavili time da ne dođete u situaciju da budete selektivni i da birate neke predmete koji su možda jednostavniji za izvesti, ali čija društvena opasnost i šteta po javnost, odnosno po javni interes je manja. I za gospodina Hicksa jedno pitanje. Kada je u pitanju međunarodna saradnja,
So for Mr. Kicks, as for international cooperation, as you have IMREM system, when it comes to international cooperation, we saw that there are some problems in international relations meaning international cooperation. What is your experience on INREM proceedings and international cooperation? And hypothetically, if Montenegro asks Great Britain to take a look at some of our transactions of our nationals over there through institutions, financial institutions there, would it be productive? Is it possible to serve that request?
Okay, there's quite a lot of questions in there. Let me just start with the human rights question. It's an important difference in the UK when we moved to the new Act, that it was no longer possible to use frozen funds to fund the defence. And so people who are being defended in the UK must rely on the public defender. But certainly at the time, the public defender was well resourced, and I am in favour, from a human rights point of view, that public defenders are properly resourced so that they have at least the level of skills as the prosecutor. And we have a system, an adversarial system in the UK to make sure that that is the case. And public defenders should be properly resourced so that the prosecutors are as good as they can be. The better the public defender, the better the prosecutor, the better the police, the better the justice. So I'm in favour of a strong public defender being in existence, but it should not be able to use, the defendant should not be able to use the frozen funds that they may have got from committing crime or that may be the proceeds of crime. So they should not have access to those funds, because the experience of the UK during the 1980s and 1990s was that defendants would use up all of the money they had made from crime to defend themselves from the charges of the prosecutor, which did not deliver justice. And that was a key change for the UK law in 2003. How do we select cases? Well, and this would be my recommendation to Montenegro, we started with the cases that were already in the process, already being investigated, perhaps already in court, and to use the new powers on those cases. And I would also recommend the thorough review of existing casework to see what has worked and what has failed in the past. So you have an understanding of how your system responds to the circumstances with which it is dealing. So how do we prioritize cases? Well, deal with the ones that you already have. The UK system, when it first began, was hierarchical, which meant that you had to start with a criminal investigation, and that had to be exhausted before it could be passed for an in rem investigation. And that was the system we chose to adopt at the beginning. I'm not sure it worked very well, because it's always possible to investigate criminally a little bit more. So it's very difficult. In all systems, I think, the start of a case and the closure of a case without a result is quite a difficult process to manage. And finally, in terms of international letters of request, it is certainly the UK's view that international letters of request in criminal cases should include the possibility of in rem litigation, if that is possible. So that as a matter of course, the letter of request in a criminal case requesting criminal restraint or freezing of assets also contains the option to freeze through an in rem process if that is possible in the receiving country. And that is, again, quite a complicated area. We would like prosecutors across Europe to routinely allow their request to be done in personam and in rem, and there is advice available from Eurojust about how to do those requests. I hope that answers those questions.
Hvala lijepo. Je li ima još neko dodatno pitanje?
Thank you very much. Is there any additional question or any question you might want to ask? Oh, yeah, there was a question for Ms. Lipovšek, I believe. Was it?
Da.
Yeah. Yes, in our situation, I'll be precise. I'll tell you what we have in the law. So financial investigation can be conducted if we have predicate or pre-criminal preliminary preparations, and if we have indications that people have some illegal proceeds over the value of 50,000 euros. So this threshold is, the value of 50,000. We believe that we should lower this threshold. Because the threshold limits us to order financial investigation. it is normal that we had the possibility to to come up with that. We found out that this the mismatch is much more than 50,000, definitely and easily, but we believe that 50,000 euros for our country, it is too high threshold, judging by circumstances we live in. So we believe that through this case, we or police, we have to establish that whether or not the threshold or the mismatch is more than 50,000 euros. So we suggest to lower the threshold. We said 10 to 15,000, but then the question is, if it is 10 to 15, and then if we can do away with 10 to 15, then why do we need that at all? So what do you think, that it would be a witch hunt of a kind? As for the threshold, I think that if we during the criminal proceedings see that in pre-criminal procedure we see that we can go for financial investigation, then we should be allowed to go for that without that threshold. So one of conditions is that the mismatch between income and the property should not be the product of the criminal offense. Should be we didn't have witch hunt with this 50,000. You know, when we applied this benchmark, we always found a criminal offense in the background. So it is just the threshold which gave us leeway or opened the way to start a financial investigation. Thank you. Are there any more questions to this? If not, that would be all. I want to thank you most cordially for taking part, and if there are no more questions, we could call it a day. Thank you, thank you. Thank you for inviting us.
Okay, thank you.
Bye.
Thank you. Bye.
Thank you. Hvala lijepa. Bye. Hvala lijepa.